Item number 54.
Regarding staying of a POCSO case, and which was brought on 27/11, it was brought by order. So now, since the matter is listed as 54, might it not reach paying for listing at 2 or before rising of the bench, because it has got some urgency since today is the date for consideration of the charge. So that is why we had paid for listing the same today.
We'll try. At 2.
Obliged.
May I please, Lordship? Lord, I am praying for Lordship item number 44, Lordship. Like criminal petition, Lordship. As per office note, Lordship, service report is waited, Lordship. Can it be taken up any other day? And I may be allowed to take fresh step. 44. Sole rest.
Service is awaited.
Service is ended. I take fresh step. Lordship.
You'll take fresh steps.
Right.
Hi, Mr. M. Khan, 44. The Warrant counsel for the petition. And it is submitted that as for office note, the charge is still awaited for the sole respondent. Accordingly, he prayed for an order to take fresh steps on the respondent number, on the sole respondent. Prayer allowed. List the matter accordingly after 4 weeks.
Another one sentence, maybe, Lordship. Register may be directed to take, give a reminder to the Lordship LCR.
LCI is not received. LCI is also not received. Issue reminder. Registry will take the necessary steps in this regard.
May I please, Lord? I beg to mention item number 26 and 27 from daily list, madam. Both of these matters will come after 2 weeks, my lord.
26 and 27.
27.
Yes, 26 and 27. What is the position?
26. Yes, they are not available.
And 27.
27 case record received.
These are NDPS matters or
My lord.
both the matters are at the request made by the so and so. How many weeks you need?
2 weeks, after 2 weeks, madam.
After 2 weeks. This the matters after.
Also scan of the charge case. 26.
Both of these are received.
Charge case.
This the matter so and so. After 2 weeks. 26, what you can write, issue reminder following the scan copy of the LCR.
Yeah, please, Lordship.
After 2 weeks.
May I please? What's our document item number 19? I have taken
19.
190. I wanted to take the counsel of the other side, legal counsel.
And the side is legal aid counsel. You are for the appellant. With the consent of the other side, slash the legal aid counsel. The counsel for the London counsel for the appellant, paid for an adjournment, prayer allowed. How many weeks you need?
December month.
List after 2 weeks.
Date may be fixed by the.
No, sorry.
May it please, Your Honor. With the consent of the other side, I beg to mention item number 53, Your Honor.
53.
53. Your Honor. In this matter, senior counsel Mr. Kindape is appearing, who hails from Tinsukia, Your Honor. So he has some personal difficulty today. So
Who is appearing here?
Askar Datta, senior counsel.
Achha. Have you informed the other
Yes,
side also?
I've taken the consent. Can it be at 17-12? He'll be here.
17, consent of the other side. 17. After vacation, you take better break after
We
vacation.
have taken the consent for 17-12, and he'll be here personally, Your Honor.
Huh?
He'll be here personally. Askar Datta, senior counsel.
17, 12 may not be possible. There are lots of matters because
Can it-
17, 18, 19 days are there. After vacation, we'll do.
Yes.
After vacation.
Intend to continue, Your Honor.
Interim was there.
Yes,
Interim will continue till next date of listing.
highly.
May I please, Your Worship? I beg to mention item number 15 for today's marriage. But I am for a response number 2, my lord. Engaged conflict in outsourcing council matter. He has some difficulties today, madam.
Who is your NGS counsel? NGS counsel is?
Happy to comment.
You are on 15.
Yes, madam.
Item number 15.
Yes, madam.
He is for the respondent. I am
Item
for
number
the.
2, madam.
Huh?
He is for the respondent. I am for the applicant.
Oh, you are for the respondent.
Madam.
And PP is also there.
Yes,
It's a
it's number 1, madam.
it's a quashing petition. So the PP is a necessary party. I am for the appellant, petitioner.
Petitioner.
So
Okay, with the consent of the other side, the learned counsel for the respondent. appearing on behalf of, yes, B,
Abir Fukon, Mr. Abir Fukon.
Mr. A. Fukan. Paid for an adjournment. When it can be listed?
11th,
After
12th
vacation.
December.
After?
After vacation.
I am
After
paying by
vacation.
11 or 12 December,
They
madam.
are-
No, 11 and
But
12
there
is
is a
full,
date.
almost full.
So after vacation, it may be.
Well, any date may be made a fixed matter. He's coming from outside matter. It's any date matter. January 1st week matter.
January 1st.
That then it be after 21.
If you take after Bihu, then
We
21.
are before we possible matter. There is interim order matter. We have proposed Supreme Court also matter in this matter matter. Possible matter before being matter.
So, why is it in one? 9.
9th, I'll be out of station, you know. I'll be assisting. 9th, I'll be 9, 10 time out of station.
7.
7.
Seven.
Court has.
No, no, we are not listing any date
Alright.
after vacation.
Interim order may be continued.
21 matter then. 21
what?
21 January matter.
January.
Yeah, ma'am.
Okay. Interim order may be continued.
21 January, interim be continued till next date of listing.
Deeply obliged.
May I please, Lord. First, I beg to mention item number 43, my lord. My lord, matter may be taken up at 2, my lord. Appellant is convicted under 376, my lord.
May not reach.
I,
Two already matters fixed.
my lord, he is in jail custody since 1.5 years, my lord. May
Maybe.
be taken up
Maybe
at
if-
2 or end of the list, my lord.
We'll
Matter-
try it. If it reaches, then also okay, otherwise not.
My lord, kindly-
Two cannot be fixed. Two matters have already been fixed.
May I please, Lordship? Lordship, item 52, Lordship, due to sudden health issue, Lordship, Mr. Foodcaster cannot be able to present with me, Lordship. So kindly it may be by 2 or 3, Lordship.
2 or?
2 or 3.
No, not at all possible.
So then
Her-
it's a.
your MS?
MS are wrong, my Lordship.
Her MS are wrong by the learned counsel appearing on behalf of Mr. A.K. Purcaster and paid for an adjournment stating that due to sudden ill health of Mr. Purcaster, the adjournment had to be paid for. Prayer allowed. List accordingly, yes. After one.
Lordship, it
After
will
2
9,
weeks.
Lordship. 9, Lordship.
No, date cannot be fixed now. After 2 weeks, it will come.
It's item number 29, my lord. I will mention item number 29, 29, my lord. It's NDPS matter, my lord. Scan copy has come, my lord, but charge has not framed yet, my lord. I have checked the scan copy, my lord. Charge has not been framed, my lord. So we'll adjourn the matter for a week now.
You are Mr. D. Bora.
D board.
D. Bora, 29, I heard Mr. D. Bora. I also heard Mr. D.P. Kusami, the learned additional PP, appearing on behalf of state respondent. Scan copy of the elsewhere has already been received. However, it is submitted by Mr. Bora that the charge is not yet framed. Accordingly, he paid to list the matter. After 2 weeks, then? After a week may not be possible. After 2 weeks or
After 2 weeks, my lord.
list after 2 weeks.
2 weeks. Oh, bless.
May I please, your lordship? Lordship, I beg to mention item number 6. Kindly pass over the matter for the deputy.
Item number 6.
Yes.
At the request made by the learned counsel for the petitioner, list the matter after 2 weeks.
Obliged, lordship.
That we have to mention for listing of an IL in connection with criminal appeal. Last
Mention before the court number 18.
deeply obliged.
Item 1, promotion.
May I please, your lordship? The petitioner is behind the bar for more than 22 days, my lord. Related to cattle, my lord. 7 cattle were recovered and they are the drivers and helpers, my lord. FIR page 9, my lord. Already, my lord, the vehicle has been seized by the police. Cattle have been already been with the police, my lord. Their statement already been recorded. So, my lord, further investigation in this case, perhaps may not be required. Yes, my lord. So
Yes,
maybe
Goswami and-
go on bail.
Okay, case I wrote it and 7 kettles are there. Already kettles were recovered.
Kettles recovered, my lord. Car is in the Jimma of the police. So
Leave it alone.
Any condition, my lord.
22 days, no?
How many days? 22
20.
days.
Any condition.
8, 11, 20.
Heard Mr. D. Sharma, the learned counsel for the petition. And also heard Mr. D. P. Goswami, the learned additional PP, appearing on behalf of state respondent. And this is an application, the section so and so liquidiva. It is submitted by Mr. Sharma, the counsel for the petitioner. That. Oh my God. কি হয় একটু বলে না নামাইব না কেরাম খেলা দিলে দেন। Heard Mr. Sharma, so and so. No, it is submitted by Mr. Sharma that the accused, both the accused petitioners are the driver and helper of the truck, which was alleged to have been, which was seized in connection with this case. And 7 numbers of cattle were recovered from the scene. He further submitted that both the accused petitioners are behind the bar since last 8/11/2022, and hence further custodial interrogation may not be necessary for the interest of the investigation. Next, para Mr. Goswami, the learned additional PP submitted in this regard, that it is a fact that the cattle and were recovered and the vehicle has already been seized in connection with this case. Full stop. Next, para considering this submission made by so and so, length of detention already undergone by the accused petitioners, I find that I got sufficient time for their custodial interrogation, and further custodial interrogation may not be necessary for the interest of the investigation. And hence, I find it a fit case to allow the accused petitioners to go on bail for rupees 20,000 each, which once you to flag amount to the satisfaction of where it is pending,
CGM Kamrup.
to the satisfaction of CGM Kamrup M. Give the other conditions also.
Deeply applied.
Item 2,
Yes, regular bail melon, small quantity of ganja melon, 30 days as on today behind the bar went.
Small quantity, but it was registered under 20B.
No, melon, A.
No, 20, I don't know, yet here it is 20B. Your petition states 20B.
2N. 8.
That is A man. But A is a small one.
No, I don't know, it is B, small b. Intermediate quantity.
In
There what is A?
in tribal order of rejected order of 20B lordship.
It is
No, melon,
20B.
8.95 can be the
20B melon, Roman 2 melon, capital A. And involve a small quantity.
Not
May-
quantity. Inventory is there 8.951 kg
Melon,
ganja.
that is there, melon, of course, melon.
Who said to small quantity?
Melon, A capital A is there.
Capital A doesn't say so small quantity. Small A speaks about small quantity. It is a capital A, you see, first,
Melon,
not a small A.
but yes, capital A.
Hmm.
20B to capital A,
Not small A.
not a small A, yes. The
That is why it's not small quantity.
22.
The case is required lordship. Case and along with FSL report.
He may be a peddler also, that we cannot say at this stage.
Well, even then either small or well, in between quantity, melon, it's 60 days a mandatory period, melon. 30 days as on today, melon.
Okay, give us small short date then.
Melon, short.
Yes, Goswami, when it can be.
10-12.
10, 12. Call for the case, right? 10, 12. Okay.
Well, that may April 9, melon. 9. Hello.
item 3,
Correct, 433, 483 application, my lord.
But POCSO is there.
The issue notice first. How about a case?
POCSO is there.
Not really.
Yes. Hard friends করে দিব decision application friends করে দিব issue notice করে দিব issue notice to this respondent number 2 no from respondent number 2 true the jurisdictional police station routed through the office of the public prosecutor and registry. Steps be taken within 2/3 days. Also call for the, as it is a not charge sheeted one,
Charge sheeted, my lord, at the stage of evidence, my lord, on the last.
charge sheeted case.
Yes, madam.
So trial court records will be required.
Also call for the scan copy of the LCR, list accordingly when it can be listed.
It's a POCSO case in charge also after application.
No, my lord, it's, my lord, already 120 days, my lord, in custody, my lord. And section only, section 10, my lord.
So 1912.
1912,
12, my lord.
list,
Last day, my lord.
name, list number of
May not
matters,
list the
19
date,
and
my lord.
20, because we have some other ones.
Some short date, they may be given
1912,
earlier.
no earlier.
1912, I think the last date, man. Before vacation, my lord.
Not last date. Last date is 20.
20.
So after before vacation is difficult, lordship. Lots of
Yes,
cases may be-
that's why, my lord. 18 may be given.
Okay, 18 then. Lots of
18,
cases were listed in those decisions.
Not so many of them. 1812.
Apology.
Item 4.
Your lordship, as on today, 3 years, 3 months and 28 days.
You were behind the bars since 3 days.
3 years, 3 months and 28 days. Arrested on 1/8/20.
What is the stage of the case at present?
Evidence, lordship.
How many witnesses are already been recorded?
Five
Five.
witness examined out of 12. Okay.
Yes, you are?
Your lordship will file our written objection. Status report to the, so your lordship may be granted.
Say
2
case of
weeks.
DRI.
Yes, lordship.
Can copy of LCR may be called for you.
Yes, that will be called for. Heard MS, you are MS,
J. Singh.
naam to likh le, so and so, and also heard you are Mr.
K. Jain.
Agent appearing on behalf of Kyle,
SC.
SC Kyle, standing counsel DRI. Call for the report, call for the scanned copy of the LCR, and it is also submitted by Mr. Jain that they will submit their written objection. Prayer allowed, list accordingly when it can be listed then.
After 2 weeks. Any
After
date may
2
be.
weeks. After 2 weeks, any days, we don't have dates. It will come after 2 weeks. Okay, after 2 weeks. List after 2 weeks.
Much obliged.
Item 3.
Item 3.
5.
Mayor, your lordship, it's criminal revision against conviction, my lord. In a PFA Act, my lord, 7/16 of the PFA Act is sentenced to, my lord, 6 months simple imprisonment. Here, my lord, only point to be decided is, my lord, section 13(2), my lord. Whether the accused received the, my lord, notice under section 13(2) or not.
13(2).
Yes, from the exhibit 20 itself, my lord, it is very clear that this, my lord, notice was not received by the accused petitioner. So I pray, my lord, lordship will kindly agree the, my lord, revision petition.
Why I is for stay?
Allowing to me to remain on previous name.
Previous.
I will report, I criminal 1161/2020. Heard Mr. B.M. Chaudhary, the learned counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application for suspension of execution of sentence and stay of realization of fine. And also paid for allowing the present petitioner to remain on its previous bail. It is submitted by Mr. Chaudhary that as by impugned judgment and order dated 24/9/2024, passed by additional session judge number 1 Kamrup M, Guwahati, in criminal appeal number 04/2021, had dismissed the criminal appeal upholding the conviction of the present accused petitioner as passed by the learned CGM Kamrup M, Guwahati, in CR case number 6357 of 2005 under section 7, read with section 16 of the PFA Act 1994, and they were sentenced to undergo SI for 6 months and to pay a fine of ₹1,000. In default, SI for another 15 days. Mr. Chaudhary further submitted that accused is already in previous bail, and during the entire period of trial, he was on bail and accordingly paid for extending paid to allow the accused petitioner to remain on his previous bail. Further, paid for stay of the suspension of the execution of the impugned judgment and order, execution of sentence passed by learned additional session judge number 5 Kamrup M in criminal appeal number 04/2021, dated 24/09/2024. Mr. Goswami, the learned additional PP, raised no objection in this regard. Accordingly, on next further, considering the submission made by the learned counsel for both sides, the present interlocutory application is allowed, and thereby the execution of sentence passed in impugned judgment and order dated 24/9/2024 in criminal appeal number 04/2021, upholding the conviction order passed by the learned CGM Kamrup M, Guwahati, in CR case number 6357 of 2005, is hereby stayed or suspended till the disposal of the connected revision petition. The petitioner is also allowed to remain on previous bail till disposal of the connected criminal revision petition. With the above observation, the I stands disposed of. Criminal revision not ahap. Heard Mr. B.M. Chaudhary, the learned counsel for the appellant, and all, petitioner, and also heard Mr. D.P. Goswami, so and so. This is a criminal revision petition under section 442, read with section 438 of BNSS 2023 against the impugned order. Baki hin likhi debo yaar par na. Admit the petition or call for the LCR. Other respondents are there, na? Only state is the respondent. Issue notice kore dibo. State is no formal notice is required to be served as state respondent number 1 has already entered into appearance. However, the extra requisite copy may be served during the course of the day. List accordingly after 4 weeks.
I'm obliged.
Item 7.
Yes. My lord, this petition filed under section 482 CFC number for quashing of an proceeding
arising out of FIR, my lord, and that is at page 11. So this is an FIR that the complainant taken a loan of rupees 60,000 from me. Now your lordship would be pleased to turn to CS, my lord. That is at page 23. Something has been submitted. Last paragraph, my lord. Under section 120B. Bottom, my lord, third line. Under section 120B, 420, 406, 506, and 384 IPC. So, my lord, my humble submission before your lordship.
P84 is also there.
384 also there. Submission before your lordship. I have given some money on interest, no doubt, and he has taken the money. Now your lordship will consider how these offences is come. That criminal conspiracy, then 420, then 406, 506, and 384 IPC. My lord, here in this case, money I have lended, my lord, there must be a registration. There must be a certificate under Money Lending Act. That certificate I do not have. So, my lord, I have committed the offense under Money Lenders Act, 1934, like this one. So, if I committed offense under Money Lenders Act, my lord, there is provision for offense, my lord. That is section 7C. Bar to carry on business without registration certificate. Section, it is Assam Money Lenders Act 1934, section 7C. No person shall carry on business of money lending unless he holds a valid registration certificate in this behalf. If that is violated, my lord, extend to 3 months imprisonment or fine which may extend to 500. That offense I have committed. Now what happened, my lord? He has come forward. I have given money. Now, case of extortion, 420. These are the sections against me, my lord. So my humble submission before your lordship, it's clear violation of section 5 of the IPC. First, my lord, clear section 5 of the IPC says that provisions of this act will not affect the provisions of special act or local acts. So it is a special act regarding money lending. So, my lord, case will go under this section, not under IPC. So it is clear violation of section 5 of the IPC. So, my lord, that is my submission. And there is no question of extension because money, in the FIR, he said, I went there, I have taken money from the accused and I have to pay interest. He is claiming interest. That is the case. Fire extortion, 420, 506, and 406 will come. Now, that is my humble submission because it is still not a case to continue.
Charge is framed already.
Charge frame.
Charges already. Under those sections only?
384 and 506.
Yes, ma'am.
Huh?
384 and 506.
384, 506.
Last page. Annex of that.
384, 506.
384, 506.
506.
So, my lord, I humbly submit. Why is 384 and 506? It's a civil dispute, my lord. And only offense is this, my lord. I have money lended without registration. That is my offense. Other offenses are not there. Because he has come for money. I have given him money. He agreed to give interest. Where is the case?
Records.
In the meantime, my lord, proceeding magistrate. Because it is completely unmerited litigation. My lord. And if it is unmerited litigation, Supreme Court said that that should not be continued. Ultimately, I will be acquitted, but after 5-10 years.
Heard Mr. M.A. Sheikh, the learned counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section 482 CRPC for quashing of the impugn proceeding in PR case number 394 of 2024, bracket of GR number 340 of 2024, bracket close, pending in the court of learned SDGMS, Nagaon, arising out of Thing PS case number 26 of 2024, 26 of 2024 under section 120B, 420, 406, 506 by 384 IPC. Issue notice to the respondent number 2. No formal notice to register AD and as usual process. No formal notice is required to be served on respondent number 1. However, extra requisite copy may be served during the course of the day. Also call for the scanned copy of the LCR. Next para, heard Mr. Sheikh on an interim pair, full stop. It is submitted by Mr. Sheikh that the allegation made against the present accused petitioner is that he used to give loan on interest and without having any license, he doing that business. But it is surprising under what basis the charge sheet was filed against the accused petitioner under section 120B, 420, 406, 506 by 384 IPC full stop. At least a case under section 7C of the Money Lenders Act may be attracted against the petitioner, but only to harass the present petitioner. The case is closed and the charge sheet is accordingly filed. He accordingly paid for stay of the further proceeding till the disposal of the present petition. Next para, Mr. Goswami, the learned additional PP submitted in this regard that though the case was charge sheeted under section 120B, 420, 406, 506, 384 IPC, but charge was framed by the learned trial court below only under section 384 by 506 IPC, considering the matrix available in the case diary. Next para, considering the submission made by the so-and-so, learned counsel for both sides, all aspects of the matter, the further proceeding in PRC case number 394 of 2024, pending before the court of learned SDGMS Nagaon, is hereby stayed till next date of list accordingly after 4 weeks.
Not so late.
Item 8.
May I please, Your Lordship? My lord, it's the instant milord, petition milord, the quashing of a FIR milord, and the FIR milord registered against me for defalcation of excess duty milord in the year of 4/8/2014 milord. Can you get the 4/8/2014? Then milord, after 2 months of the said FIR by the same excise department, another complaint lodged against me from the same sets of allegation milord before the learned CJM milord, Kasar milord, and that is on 16/10/2014 milord. That means for same cause of allegations, milord, one is FIR, another is complaint. Thereafter, milord, what happened, milord? On 12/2/2023, milord, the excise department read an withdrawal application before the learned CJM court. The case pending before the complaint case, they are willing to withdraw that. Accordingly, milord, considering the withdrawal application, the learned trial court, milord, allowed to withdraw and acquitted me from that allegation. Milord, can it, that orders Annexure 7, milord, and page 32, can we have a look, milord? under section 321 CRPC for withdrawal of the above case as per the notification number so by the state of Assam. In the instant case fall within the purview of the said notification, the government of Assam has decided to withdraw such cases. On perusal of the record and your petitioner is satisfied that the case be withdrawn as per the notification dated so. Might order it at very next page. That is on 15 March 2023, my lord. On the previous date, learned additional public prosecutor appearing for the state of Assam has submitted withdrawal application file number so dated so. The government notification stating the instant case pending before this court for trial subject to be withdrawn by the government of Assam and that this case does not come under the exception provided by the aforesaid government notification. Thereby learned additional public prosecutor has prayed to allow the withdrawal petition and proceeded to dispose of the case as per 321 so. Had a learned counsel for the parties on petition number so. Upon such perusal of the hearing, it is seen that the cognizance was taken under section 54-58 of the Assam Excise Act 1910, the accused, namely accused Devottam Roy. The further direction of the government of Assam list of the cases of the SOP were already been notified and published in so notified. It also appears that the case is pending at evidence stage. The offence under section Assam Excise is punishable under imprisonment up to 3 years. Moreover, the case is instituted on filing of the complaint by the Pulin Kumar, the inspector of excise Silchar so. I have also perused the government Assam by notification dated so and list the case forwarded to the public. It appears the government of Assam has sent a letter authorizing the public prosecutor to withdraw the case. Very next page, below. Therefore, in view of the filing withdrawal petition by the learned additional PP and the fact of the circumstances of the case, the consent for the withdrawal of this case is granted as per the section accordingly. The withdrawal petition is allowed. Situated in view of the section 321, Devottam Roy is acquitted in respect of the offence under section 54 the case disposed of. That means, my lord, that complaint case they registered, my lord, on 2014 to October, it is withdrawn. My lord, the affair, my lord, which I am under challenge here, below page 17 and Annexure 2. That is registered on 4 August 2024, my lord. Sorry, 2014. With reference to the subject cited above, I have the honor to inform you that on recollection of the excess duty collected during the period from 11/12 to 14/15, with the receipt schedule obtained from the Kasar Treasury Silchar, a defalcation of rupees and the two numbers of the licensee are found to be involved in the defalcation of excise duty, and amount of excise duty defalcated by the two licensee are given below. My name is 1 million. The Devottam Roy, rupees of censure. By the superintendent of excise duty and cases registered under section 409-420. Since Milord, after lodging of this instant affair, Milord, my MFL license was cancelled, suspended, Milord. From there is on very next page 18 and Annexure 3, 13 August 2014, Milord. Now my humble prayer before this court. Since saying similar sets of allegations, my lord, now another application, the complaint, my lord. Complaint petition, page 25, Annexure 5. It was filed on 6 October 2014, which was withdrawn subsequently, my lord. The lordship will file, my lord. Paragraph 6-7.
Page number?
Page 20, page 26, my lord. Of the complaint, which was subsequently they have withdrawn, my lord.
Yes.
That the Deputy Commissioner Kasar Silchar, by the order dated 4 August 24, suspended the IMFL license of the Devottam. Thus, you know, the Annexure 3, that letter I have shown your lordship, that my suspended IMFL license, my lord. A violation of the provisions of 29(1) of the Assam Excise Act in limitation of the Commission Secretary to the Government of Assam Excise Department Dispute Commissioner Para 7, my lord. That on the basis of the order dated 4 August, that is the FR registering date, 4 August 2014, by a Dr. Inspector of Excise and Office in charge, warehouse in the Executive Magistrate, Kasar Silchar, went to the licensee premises of the accused person as per the provisions of law and seized IMFL and BER, and there were the kept inside the license premises due to logistic problem and seized the premises in presence of the Executive Magistrate present, and accused was found to absconded to license and permit pass stock and sale registers accused of the were not found in the premises seizure. That means, my lord, paragraph 17, then 4 August 2024, already they have registered one FIR against me. It's not even single whisper made that one already on the same ground of defalcation of excise duty. They have not even stated, my lord. For the same allegation, one FIR, one complaint. And complaint subject, they have withdrawn 2014 lodging complaint, they have withdrawn on 2020. But what happened, my lord? How I am agree, my lord? For the last 10 years, neither charge sheet file nor any FIR file in this case. For the last 10 years, that FIR is pending against me. Because of this ground, my lord, they are not issuing a fresh license to me, my lord. They have illegally suspended without having any evidence against me. Now, my lord, on this ground, my lord. Already Honorable Apex Court is very much clear on this point, my lord. The lordship pardon me, only 2 citations I have to rely, my lord. The absolute
The
violation.
counsel for the excise is there, no?
Yeah. His presence is also will be required, madam.
It
That
should
is
be
one point,
required,
madam.
required. Department of excise is there.
Last occasion also, well, this Honorable Court has asked him to appear, but he has not appeared, my lord. We serve copy, my lord, excise department. D. Gogoi.
Can he be informed?
Which I.
Because it's a
Monday,
case of this.
can it be on
excise.
Monday?
Then Monday, my lord.
Monday, because whether he will be there, whether he will be ready with.
The lordship may fix it for some time, my lord, if he's a,
And the name may be shown, madam.
Name is shown here.
Name shown, no?
D. Gogoi's name is there.
yes, yes.
Name has already been
I will
reflected.
inform my lord, let it be on Monday, madam.
Listing on Monday. Today he may not be there. Or what?
And also, my lord, we cannot say, madam.
But can it be at 2 o'clock, my lord? In the we'll try
Monday,
to-
2 o'clock.
And today, my lord.
2 o'clock already matters have been fixed.
Then Monday. my lord.
Monday,
Okay.
please try.
I'm also.
List on Monday. This I'm keeping here.
Yes, yes, my lord. Date your best.
Item 9.
Monday is Peter.
May I please, your lordship? This is an application to quashing lordship, a criminal proceeding arising out of a FIR lordship. Impugn FIR is at page lordship 16, lordship.
1-6.
1-6, lordship. Whole allegation is under section lordship 67A of IT Act, lordship, and on that basis, lordship, other sections are also alleged, lordship. In this case, lordship, what happened, allegation is that I have taken the mobile phone of the informant, and after taking the mobile, and I have collected the photos, personal photos, and I have made viral from my mobile phone, lordship. After completing search sheet, lordship, IO had filed a search sheet, and accordingly the proceeding is going on, lordship, and charges has already been framed, lordship. Lordship, here, lordship, IO had filed the search sheet, lordship. If lordship peruse the search sheet, lordship, at page 24, lordship, here are all witnesses that are enlisted in the search sheet, lordship, are interested witnesses, lordship, and no material evidence has been collected by the IO, lordship, to establish the allegation, lordship, against me, lordship. So in the search sheet, lordship, the witnesses that are enlisted, lordship, the number 1 is, lordship, the informant, and number 2, 3, 4 are the family members, lordship, the brothers of the informant and the father, and number 5, that is the IO, lordship. And nothing has been seized, lordship. I have my engaged counsel, lordship, during the framing of search, lordship, argued about the fact that, lordship, no material evidence was collected, lordship. So charges, I may be acquitted, lordship. That was not considered, lordship. So in this case, lordship, if the
And at
proceeding,
the time of charge, you also filed one petition
lordship, oral
for the
argument,
charge.
not on the,
For not framing charge.
not framing charges,
Acha.
lordship.
Or for not paying charge or for your discharge, whatever.
Lordship. Lordship, the IO has only filed the, lordship, search sheet. No material evidence was there, lordship. Only with the search sheet, lordship, he has filed, lordship, a sketch map and a bond lordship. No independent witnesses are their lordship. And my mobile phone was also not seized lordship. Although I have given all the details of my FB accounts and the Instagram, the basic allegation is that lordship I have made viral lordship through my FB and Instagram account lordship. But I have investigated into lordship and might be he had not able to collect anything against me lordship. That's why lordship he had not been able to give any evidence lordship. So further proceedings will be fruitless proceeding lordship. So lordship proceedings may be stayed and lordship.
Yes,
No, only notice, my lord, no stay, my lord. Your lordship will find page 33. Okay, your lordship, last page, lordship.
Basically, lordship section is
I have perused the case diary and case record. It appears that section 12B is not applicable. However, I found materials against the accused persons under section such and such. Accordingly, my lord, charges are framed, my lord.
So
So
those
let
are
your
lordship.
respondent number 2 be given.
Apart from lordship,
Otherwise,
section 67A of IT Act lordship, all are the PT offences lordship. No, not more than 3 years lordship imprisonment lordship. So if the allegation of 67 IT Act will not establish, then other sections will also not be applicable lordship.
he is also under bail, my lord, so no application of any.
I am an advocate
So
lordship.
let it be.
Petitioner is an advocate lordship.
There are lots of cases against the advocates.
Yes, my lord. Because
I have come across many.
Lordship, I am an advocate. I am practicing their lordship against me
Yes,
lordship.
yes, that's why I told you. Yes, yes, 4 or 5 numbers of two just 3 weeks.
Lordship,
And all are advocates.
lordship.
If they are done this with this kind of.
Lordship, so some personal cases may be their lordship. So this might be. I am married person lordship, and my image is
That then
Then
too, you
they-
should
then-
have. You should have.
lordship it is empowering in my profession lordship.
Yes. But you are on bail, I think, no?
I'm
You are Mr.
Just fix for
MH.
evidence.
no,
MH.
lordship. I am S. Ali. My name has not been enlisted. No?
Oh, achha, achha.
No,
Heard Mr. S. Ali, the learned counsel for the petitioner. And also heard Mr. MP Kuswami, the learned additional PP, appearing on behalf of state respondent. This is an application, but he likhi issue notice to the respondent number 2 to register DD, and as usual process, no formal notice is required to be served on the respondent number 1. However, requisite extra copy may be served during the course of the day. Also call for the scanned copy of the LCM, list accordingly after 4 weeks. Stay is not a case of stay, huh? I cannot pass. It's not a case of stay. Now we cannot appreciate entire evidence at this stage also. Not a case of stay.
Lordship, one more prayer,
With 4
lordship.
folks.
One more prayer, lordship. The petitioner's name has been wrongly enlisted in the cause list as well as in the site, lordship. It should be lordship Asif Hussain, not Ahib Hussain, lordship.
Asif.
Asif Hussain.
In your petition, it is correct? It is correct.
In my petition, it is correct, lordship. Asif Hussain Siddiq, lordship. In the cause list and the system, it is appearing as Ahib.
Can it be now? Or register may be direct.
So what happened, lordship, when certified copy of the order will be?
You are Mr. Asif.
Yes, it is an
ASIF.
SIF, lordship.
Here it is Ahif. No?
Yes, lordship.
Further it is submitted by Mr. Ali that in the system as well as in the cause list, the name of the petitioner is wrongly mentioned as Ahif, 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 instead of ASIF, Asif. The registry is accordingly directed to correct the name of the petitioner in the cause list as well as in the system. Okay.
Deeply obliged.
Item 10.
Some contaminant substances from the formation of 5 accused. And quantity recovered from each accused is lesser than commercial quantity. But all these quantities have been clubbed together and make it lordship the commercial quantity. And case was registered in commercial quantities. Charge sheet was submitted subsequently. Lordship charge has been framed.
But one thing you say, was there any 29 section? Section 29 is
29
there.
is there, but there is no allegation in the FIR itself, FIR as well as in the Lordship, some charge sheet and other documents, Lordship. Because these persons are belonging to different states. And they were in the train and
Now,
Lordship.
see, that is the issue from the
Right.
different states like Bihar, UP, or sometimes like Odisha and other states like nearing by states like Manipur, Mizoram, they are doing all these things.
Well,
This
that is
business is
correct,
there.
but that is correct, Lordship.
That
But
is why you cannot say that
They-
he is from other states.
they are, Lordship,
They are
not
from
linked
the
to
other
each other.
states itself. In the Rajdhani, there are lots of this contraband were recovered from the people who belong to the other states.
I love that part
That
is to come in the investigation, Lordship.
Obviously, investigation, it has come, that's why charge sheet is there.
But that is charge sheet given, but to that effect, Lordship, section 29, there is no conspiracy, abatement, etc. has been.
Okay, then we will issue notice at this stage. There cannot be any stay at all.
So
Not
notice
at
that
all.
mother on them LCR maybe the second copy of the LCR may be called for.
Yes, and who is this number 2 it may not be required, I think, no?
Number 2 is the police officer.
Can represent to me.
You can represent, that's fine. Heard Mr. M.H. Khan, the learned counsel for the petition. Also heard Mr. D.P. Okay, R.J. Borwa, the learned additional PP. So and so. And this is an application under section 528 of BNSS for quashing the order dated 9/7/2024 passed by learned special judge Bongaigaon in special bracket of NAR case number 50 of the 50 bracket of BGN of 2024, whereby the charge was framed, na?
But charge frame.
Charge
Page
frame.
28.
Charge frame against the accused petitioners. Under which section charge frame? Page 20.
Page 28, Lordship.
Page 28.
20B, Roman 2, C 29.
Charge frame. Under section 20, small b, small Roman 2, capital C of 2020/29 of NDPS Act. Full stop. Issue notice to the respondents. However, no formal notice is required to be served on the respondent number 1 and 2, as state is representing both the respondent number 1 and 2. Additional PP is representing. However, extra copies may be served during the course of the day. Call for the scanned copy of the LCR. List accordingly. After 4 weeks, will
Can it be, Lordship, after 2 weeks, Lordship, any date may be given? This is a trial case, Lordship. As your Lordship is
not possible, not possible now.
As your Lordship is not.
You have seen this.
Obliged.
Level.
Yeah, please go on. The criminal petition, your Lordship. Under 528, your Lordship, of BNS. Challenging the FIR charge sheet, your Lordship, submitted against the petitioner, your Lordship. And charge sheet was submitted under section, your Lordship, 376, 493, and 323 of the Indian Penal Code, your Lordship.
376.
493, 323. Your Lordship may kindly come to page 21, the vernacular of the FIR, your Lordship. Vernacular version of the FIR. May I read, your Lordship? সন্মানপূর্বক বিনীত নিবেদন এই যে যোৱাকালি 31/8/2023 তাৰিখে মোৰ প্ৰেমিকে তাৰ নিজৰ ঘৰ মোক গুৰুতৰভাৱে গুৰুতৰ মাৰধৰ কৰি ডিব্ৰুগড়ত পেলাই থৈ যায়। তাৰ নাম প্ৰজ্ঞান চুতীয়া। টিংখাং ৰতনপুৰ নিবাসী যতীন চুতীয়ালৰ প্ৰজ্ঞান চুতীয়াৰ লগত এবছৰৰ পৰা প্ৰেমৰ সম্পৰ্কত আছিলে। সি সামাজিকভাৱে নহলেও মোক প্ৰেমৰ সম্পৰ্কৰ বিশ্বাস দি সেন্দুৰ পিন্ধাইছিল। মই জনা নাছিলো সি আৰু তাৰ ঘৰখনে মোক মিছা আশা দি ৰাখিছিল বুলি। মই যিমান বাৰে তাক লগ পাবলৈ তাৰ ঘৰলৈ গৈছিলো সিমান বাৰেই মই যিকোনো কথা উলিয়াই তাৰ ঘৰৰ মানুহৰ লগত মোক মাৰপিট কৰি বেয়াকৈ বহুবাৰ গুৰুতৰভাৱে জখমো হৈছিলো, কিন্তু ভাল পোৱাৰ সম্পৰ্ক আছিল বাবে সহ্য কৰি আছিলো। যোৱা 31/2023 তাৰিখে সিদিনা কাৰণত মোৰ ডিউটি চেফ এগৰাকীক ৰাতি হাৰাচমেণ্ট কৰে, ফোন
মেছেজ কৰি পুলিচ কেছৰ ভয় দেখুৱাই সিহঁতকে মোক ডিউটিত অপমান কৰা হয় আৰু মই লাজ অপমান পাই এইখিনি কথা ক'বলৈ প্ৰজ্ঞানৰ ঘৰলৈ গৈছিলো গৈ পোৱাৰ লগে লগে মোক বেয়াকৈ মাটিত পেলাই হাত ভৰিৰে কঁকাল পিঠি পেটত পৰে মই গুৰুতৰভাৱে আঘাতপ্ৰাপ্ত হওঁ মই খোজকাঢ়িবলৈ অসুবিধা পাওঁ মাৰৰ পৰা ৰক্ষা পাবলৈ মই ওচৰৰ ঘৰ এটাত সোমাওঁ আৰু সি আৰু তাৰ মোমায়েকে মিলি মাৰপিট কৰাৰ বা মোৰ ওপৰত অত্যাচাৰ কৰাৰ ভিডিঅ' বনাই মোক মাৰিবলৈ জোৰ কৰে মোৰ মানসিক স্থিতি বৰ বেয়া অৱস্থা মোৰ পেট কঁকাল বুকুৰ ওপৰত হাত ভৰিৰে প্ৰহাৰ কৰি মই বেয়াকৈ আঘাত পাওঁ এইবোৰ দেখি শুনি অলপো দুখ অনুভৱ নকৰিলে মোক ধৰি কৰি ডিব্ৰুগড়ত থৈ যোৱাৰ পিছত মই ফোন কৰাৰ পিছতো এবাৰো ফোন নুঠালে সেন্দুৰ লৈ থৈছো বাবে মই আঁতৰি আহিব পৰা নাই Now, this is the allegation, Your Lordship. On the face of it, Your Lordship, probably 376 will not come. And therefore, Your Lordship, the Honorable Court was pleased to grant me, Your Lordship, pre-arrest bail, Your Lordship, in the present case. I am an employee, Your Lordship, with government agency, Your Lordship. And in fact, Your Lordship, it is a fact that we are in a relationship, Your Lordship, and in fact, still in a relationship, Your Lordship. And out of Your Lordship, some misunderstanding, quarrel, Your Lordship, this affair has been lost, Your Lordship. Now, Your Lordship, she has subsequently filed an affidavit, Your Lordship, before the police saying that this is out of misunderstanding, I have lost the case and I don't want to proceed with this. That was part of the, still part of the record, Your Lordship. In spite of all these, Your Lordship, they have charge-sheeted me under section 376, Your Lordship. And Your Lordship will kindly see the language of the FIR, Your Lordship, they have used, and Your Lordship, at the end of the day, Your Lordship, charge sheet is filed under section 323, Your Lordship. Simple injury, Your Lordship. We don't know whether that is been caused by me or not, Your Lordship. Then Your Lordship may kindly come to the charge sheet, Your Lordship, for a moment. What is the ultimate finding of the investigating agency after page 34, Your Lordship? Brief facts of the case. First paragraph, Your Lordship, clause 16, that is the narration of the FIR. Then, Your Lordship, next page, page 35. During investigation, visited the place of occurrence, drawn up the sketch map. PO examined the complainant cum victim witnesses and recorded their statement under section 161 CRPC. Also recorded the statement of victim judicially under 164 CRPC before the Honorable Court, where she stated that she had love relation with the accused Pragyan Sutia and they had physical relation also. As the accused put sindoor on her forehead, thus he did physical relation many times with her. Further, he started to ignore her and threaten her and also physically assaulted her at his house and also refused the court marriage. This is the, Your Lordship, gist of the case. Now, Your Lordship, can these allegations bring 376 against me, Your Lordship? Under no stretch of imagination, Your Lordship. And secondly, Your Lordship, knows, Your Lordship, recent judgment is also there from the Honorable Apex Court, Your Lordship. Every breach of promise there is no breach of promise. We are still in relationship, Your Lordship. But even assuming that there is breach of promise, Your Lordship, can every breach of promise, Your Lordship, bring someone within the ambit of section 376, Your Lordship? That cannot be. That cannot be. And you see, from the language of the FIR, from the what has been found in the charge sheet, Your Lordship, that she is a consensually, even assuming there is something, Your Lordship, it is consensual. After being in consensual relationship with me for quite some period of time, probably, Your Lordship, one cannot go back and say that, yes, this is rape. That cannot be, Your Lordship. This is judgment, Your Lordship, very recent judgment, Your Lordship. Mohesh Damu Khare versus State of Maharashtra and another. Here, Your Lordship, the Honorable Apex Court has clearly held, Your Lordship. I don't have the copy right now, Your Lordship. This I have downloaded. Yes. Therefore, Your Lordship, my humble submission here in Your Lordship may call for the record of case, Your Lordship. And since, Your Lordship, prima facie, Your Lordship, there is no.
So where is the document have we annexed that he
Affidavit.
already filed before the
Affidavit. Yes, yes. Your lordship will get it at page 25. 24 and 25, your lordship. Sorry. Now, ultimately, your lordship, continuation of this proceeding will only hamper our relationship more, your lordship.
My lord, since my learned friend has already submitted, my lord, the continuation of this proceeding will hamper their relationship, my lord. My humble submission is that since charge sheet has been submitted, my lord, let the victim be examined before the trial court. If she deposed before the trial court, my lord, the matter will be ended as, my lord, very single day, my lord. There is no requirement to, my lord, introduce further evidence, my lord. Because, my lord, ultimately, my lord, the investigation is completed and my charge sheet has been submitted, my lord. My lord, assuming, my lord, it's a maybe a case, false case, my lord. But the question is that, my lord, after investigation, my lord, considering my lord, materials are recorded, my lord, statement with witnesses, my lord, examined during the, my lord, investigation. Charge has been submitted, my lord. So, my lord, in this case, my lord, victim, my lord, notice be issued, my lord. And, my lord, it will the trial of the entire proceeding will, my lord, come to an end if the victim is examined, my lord. There is no required to, my lord, stay in proceeding, my lord. If it is stay, it will stay for, my lord, 1-2 years, my lord. But if the victim is examined in the court, my lord, if he deposed, my lord, that the case is filed under some misunderstanding, my lord, and they want to get married. What about?
How much the court considers generally? Generally, court considers.
Lordship, just I am giving short reply, your lordship. The para 31 I am reading, your lordship. In our view, criminality is to be, if criminality is to be attached to such prolonged physical relationship at a very related state, it can lead to a serious consequences. It will open the scope for imputing criminality to such long-run relationships after turning sour, as much as such an allegations can be made even at a belated stage to drag a person in the juggernaut of stringent criminal process. There is always a danger of attributing criminal intent to otherwise disturbed civil relationship of which the court must also be mindful. This is what very
That's
recent.
what he is submitting. The question is that charge sheet case has already been charge sheeted.
Lordship.
Now case file most probably next date will be fixed for evidence, and obviously evidence will be recorded for the victim slash the informant, whatever.
Lordship.
So if she says before this court, then no court shall, I mean, it is the intention of the court that do not going to disturb the relationship.
Lordship will kindly
But-
see once your lordship charge sheet is submitted, your lordship, prosecution until and unless your lordship entire evidence is taken,
no,
your lordship,
no.
that probably no court will do. Your lordships can always look into the, your lordship, there are many cases, your lordship, where your lordship police file charge
At
sheet.
best 2 or 3, maybe sometimes 1 or 2 supporting evidence for requirement, they may be there. Otherwise, if the victim comes and says that I don't have any objection, or that was only merely understanding.
Let
that
your
was it.
lordship may all for the record, your lordship, but scan copy your lordship. At the end of the day, your lordship to see your lordship whether your lordship the materials are available or not, your lordship. In many cases, your lordship yourself has quashed
Again,
lordship.
charge has already been framed.
No, your lordship, charge has not been framed.
Or his appearance, my lord.
Appearance. It is in the stage of appearance. Charge has not been framed. My only question is, your lordship, when on the face of it, no case under 376, how police investigating agency without applying its mind can submit a search sheet, your lordship, under that section? That needs to be looked into by this honorable court, your lordship.
Now see, there may not be, but the question is that she was having sexual relationship
Yes, your
with the accused only on the that she was under impression that she already got married with you. That is the 493. That may be one of the under that pretext or under that promise. He might have that may be the viewpoint of the IO. That's why these charges.
Lordship will kindly see that if 493 will come, can 376 come? Your
No,
lordship?
it cannot come. But
Can
the question
three-
is 493. The 490 if 493 comes, obviously you are rightly submitted. 376
Cannot come. That
Cannot
shows
come.
your lordship that
That
there is
cannot come.
non-application of mind. That reflects non-application of mind.
My lord, charge has not yet been framed, my lord. So they can place all the materials, my lord. including the, my lord, the affidavit of the, my lord, victim informant, my lord. The time of pending charge, my lord, then he may be, there may be a chance that he may be discharged also.
I cannot, your lordship. Supreme Court order is very clear. At this stage of charge framing, I can't submit any document, your lordship. That's law is settled, your lordship. Your lordship may call for the record, your lordship. And I will take your lordship dusty service, your lordship.
She can also appear otherwise.
Lordship.
Then the notice may be.
Heard Mr. S. Waterford, Dewan Counsel for the petition. And also heard Mr. R.J. Borwa, Dewan additional PP, appearing on behalf of state respondent. This is an application on section 528 BNSS. Read with Article 227 of the Constitution of India for setting aside and quashing of the impugned FIR. FIR number 101 of 2024, registered under section 376/493 by 325 IPC under Tingkhong police station, and also paid for washing of the charge sheet bearing number 21 of 2024, dated 29/04/2024, and the entire criminal proceeding pending before the learned GMFC Dibrugarh. Post. Next para, issue notice corridor. Respond number 2, no formal notice is required to be served on so and so. Also call for the scan copy of deals. When your date is fixed, just can you tell us?
Yours.
Prior to that, we may file.
Next date, I will be given.
Prior to next date, if it
Lordship,
can be fixed, just give us the
Lordship, I will give.
list accordingly. Go to the only date to the date. We are listing it prior to that.
Lordship. Deeply applied.
I think 12.
Yes, yes.
Because it's an application for washing of NPWA. They say improved orders at 16 and 17 pages. So what happened? This petitioner was appeared before the trial court below in Guwahati Metro, Kamruk Metro, and his petition has been allowed. He's allowed to go on 10,000 bail. Therefore, he furnished one bail bond, and they said bail bond is rejected, and said that unsatisfactory. Thereafter, time has been over. He intend to deposit the cash amount 10,000, and he went out with permission of the bench assistant.
Went out means?
Went out from the court for withdrawal amount. And thereafter.
And he deposited the amount before the bench system?
No, at that moment he had out of pocket notion. He don't have the money. So he went out to withdraw money from the ATM booth with permission of the court, bench assistant. And thereafter also time has been over and custody warrant has been issued. And below has been issued there.
No, within the entire day, he could have appeared before the.
Yes, but
at a time he went out, obviously, but
time has been over. 5:30 has time. Evening.
Then how can you say that he went to take out the
But
money?
it is
He
reflected in the order
fled
that-
away from the court campus, that means.
Yes, reflected that he has fled away from the court.
Oh, obviously.
Plus it is with permission of the bench assistant, he went out. And he will appear on next date. He's a practicing lawyer. This is the main issue.
See, all the lawyers are there, in
Yes.
fact, all men.
But cases registered under or succeeded under 341, 320, and 294. All sections are bailable. And engaged counsel had even requested the court below for PR bond also. They're very only punishment is 2 years.
So where is the order, impugned order?
16 and 17 days. 16 is where bail is allowed, and in next phase 17, custody warrant and NPW.
On the
Same.
22nd of November, his bail
Yes.
bond was rejected.
Yes.
Not found satisfactory.
Yes, yes.
Then when it was asked that the
Same day. Next date is 3rd of December. Will be appear lordship, definitely. New council lordship.
So being a counsel, he should know rather, I think.
Exactly, man. Being an advocate, my lord, he
Yes.
knows, my lord, everything, my lord.
Oh.
In spite of that, my lord, he has committed this mistake, my lord.
He got only.
He could have, my lord, he could have requested, my lord, another trial
Yes,
court,
yes,
my lord.
yes, lordship.
That's
Directly to the court
Yes, my
itself.
lord, the court would have fixed another date, my
Mm,
lord,
that-
for his appearance.
If I may be allowed to give the cashier.
But he,
Exactly.
he made a request for PR bond. It was not considered.
NBW may be state, my lord, and it won't hurt, my lord. Directly to
But he'll be
appear.
appear, definitely.
So the regarding bail bond, my lord, it's a discussion of the trial court.
Yes,
It's obvious. Yes. Yeah, Mr. Palita.
No,
G.
G.
Pukon.
Pukon,
G.
lordship.
Heard Mr. G. Pukon, the learned counsel for the petition. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section 528 of BNSS for quashing of NBWA issued against you. Order you have not challenged.
Yes, I have a challenge the order, lordship, to this.
It is not
Repeat order.
mentioned here.
Yes, lordship.
2211
Yes, lordship.
for sitting as a quashing of the impen order dated 22/11/2024 in PRC case number 1283 of 2024 passed by learned JMFC Kamrup M Guwahati, whereby the NBW was issued against the present petitioner. Next para, it is submitted by Mr. Pukon, the counsel and counsel for the petitioner, that on 22/11/2024, the present accused petitioner, who is a practicing lawyer, was allowed to go on bail by the learned trial court below for rupees 10,000, along with one surety. But his bail bond was rejected as the bailer was not found satisfactory. Later on he was intent to give the cash surety, and accordingly, by informing the bench assistant, he left out of the court premises to take out the cash amount of rupees 10,000 to furnish as a surety. But as the time was over and he could not come before the learned trial court below, it was the NBW was issued against him with a view that he had fled away from the court premises. But there was no such intention of the present petitioner, and he went out of the court premises only informing the bench assistant to take out the money from the ATM. But in between, as the court working hours of the court was over, the NBW was issued against him. He is ready and willing to appear before the learned trial court below and to contest the case accordingly, if he is, and accordingly prayed to stay for the NBW issued against him, allowing him to appear before the learned trial court below. Next para, Mr. Borwa, the learned edition PP, submitted in this regard that a petitioner may be directed to appear before the learned trial court below with an appropriate application for bail. Next para, considering the entire submission made by the learned counsel for the petitioners and the considering the circumstances of this case, I find that I hereby directed the present accused petitioner to appear before the learned trial court below with a fresh application for bail, which may be considered in accordance with law. Till the next date is fixed on 3/12.
3/12.
And till next date of listing that is on 3/12/2024. The NBW issued against him be stayed or be suspended.
No.
With the above observation, stand dismissed.
Leave no question.
30.
May your lordship, my lord.
Yes.
This is a case matter where I find my lord's husband and a wife both coming together, my lord, there, my lord actually made a my lord theft of the present petitioner in this case, my lord. It is a video, my lord. He is a video. And the informant, the husband, he was by having some restaurant card, etc., with some other person. Sometimes he offered money to me. I refused, I have given warning to him. So this made him some sort of to give him little lesson, my lord. Subsequently, the wife made a story, just your lordship kindly see, page 11. Your lordship, page 11, next 2, my lord. FIR lodged by the wife, husband also filed on the same day on the same my lord allegations. So respectively,
this is filed by the wife.
Yes, wife.
And who is the husband?
Husband, that's other one. I'll show you your lordship. Let us first see that this one here, page 11. About 1 year back, when the below named accused was working as a block development officer at Vidyapur. That is wrong, my lord. I have never worked at Vidyapur. Your lord kindly knows I have never worked at Vidyapur. Yeah. So first, your lordship kindly see that one. I was introduced with him when I went for my ration card purpose and took my mobile number. The accused used to adjure me in various ways and proposed me for love FIR. Accused is presently posted as block officer at Hojai. For last 5 months, I have been posted, my lord, in the district of Hojai, but block is different. For the last few days, the accused enticed me over phone to give a job and told me to come to Hojai. On 13/11/24, your lord kindly note my 13/11/24, I kept my minor child, your lord in my parental house, and by telling my husband's family that I would visit my friend's house at Nagaon, went to Nagaon and contacted the accused. She herself came, she contacted the accused, your lord kindly, keeping the child, telling lie that I'm going to my friend's house, but instead of going to friend's house, she came to Nagaon, contacted me, and then I took her. That is the allegation, madam. My minor child in my parental house, and by telling my husband family that I visit my friend's house at Nagaon, went to Nagaon, contacted the accused, who then took me in his car from Nagaon to his official quarter, where I was confined for 2 days. He forcibly my so-and-so. Thereafter, he dropped me at Nagaon. Although I came to my residence husband's house, but due to recording of some scenes of my so-and-so, he made it viral in the social media, due to which honor of my husband and our family is harmed. On the face of it, my lord, whether you also kindly see my custody, I am 59 years old, going to retire after 7-8 months, my lord. I'm going to retire. At this stage, she is making my this lie. She has come in the name of coming to friend's house. She contacted as per her. Then my husband, what husband is saying, my page 18, my page 1. Same day.
On the same day, another affair.
That was my lord actually supplementary FIR. It is treated to some GD entry was supplementary, my lord. Not the same, the separate number is not there. GD entry is there. Same, my lord, he is saying the same thing. Husband also, page 18. 1 year back, the below named accused was introduced with my wife, so-and-so, while accused was working as a block development officer at Vidyapur. This is wrong, my lord. Vidyapur is 20 kilometers away from I was in Sijonga development block. 20 kilometers away from Vidyapur, my lord. They are from Vidyapur. There is no occasion to go to my block, my lord. They have gone to another block, Vidyapur block. I have never been posted at Vidyapur block, my lord. The whole story is based on my lord, this conflicted story, my lord.
So what is your story?
My story is, my lord, your kind I have given, my lord, my story. Husband. My story is the husband, my lord. Paragraph page 4, paragraph 4, my. And in the quarter, I live with my wife, my son, my daughter, medical student. In the quarter, maid servant. I live in the quarter, my. Now, page 4, paragraph 4, you lost guys. Second line, the actual fact is that while the petitioner was posted as a block development officer at Sijongram Development Block under Bangladesh district, informant husband used to visit in the block office for making ration cards of different persons by accompanying them in exchange of money. He takes money from them and he brings them to the office of present petitioner. However, the petitioner asked the husband of the informant not to come for such work of other persons, but he did not stop, due to which the petitioner warned him for taking action against him. Then the informant, at the instance of her husband, came to his office at Sijanpur block and requested him not to take any action against her husband. Your lordship got it. Thereafter, the informant visited his office on various pretexts and requested him to provide any job. Petitioner told her that he cannot give any job to her as he has no authority, such authority. Then the informant's husband threatened the petitioner to teach him a lesson by using his political connection, as he knows many political leaders of the ruling party. But the petitioner did not respond to it. Thereafter, when the petitioner was transferred to Hojai about 5 months ago, the informant lost the instant case belatedly after about 10 days of the accident occurrence. The petitioner was never posted at Vidyapur, your lordship. Never posted at Vidyapur at any point of time, which is about 20 kilometers away from Sijanpur block, where he was posted. Be it mentioned that the husband of the informant also lodged in FIR on the same allegation which was entered in Bangladesh GDNT number so and so forth and so on. So how these sections are attracted against me, I am only on that mind. A person might have 59 years old, 59 plus mind, going to retire responsible officer. The story was purely matter. It is a concoct story matter. My parents matter, your logic in the meantime, it is a 1 month segment one subject to what my unfair say. This is a case for internet, my lord.
My humble submission, my lord, at least as my lord, let the case very big call for my lord. Because from the perusal of the FIR, my lord, there is, my lord, some connection with the, my lord, informant and the accused person. It is why, my lord, when my lord, telephone call was received, my lord, she went to my lord Hojai, my lord. Thereafter, my lord, that incident occurred, my lord.
She came to Hojai.
So let the case very call for, my lord. I am submitting on the basis of the first FIR, lord. Because the second FIR is also, my lord, more or less in the kind of same nature.
Same, yeah. My whole case was whether the section applied or not.
That will investigate.
She has none that on the face of it. Why do your lordship having vast experience? Your lordship knows from the FIR man. She is coming by telling lie that I am going to my friend's house. Who is here? I have got her or she got. Suppose assuming that it is correct one. Who is involved? She is major lady having children, keeping child in her house. She came, my. And if you, I think it is a case for interim matter. Then officer, my lord, he will be there.
What to do? She came for a job only.
Yes. No job. So I said I cannot give job. Job is
No,
not.
you're offering job, na?
No, man. Not job. Job cards.
Oh, job cards.
Not job, my lord. I said a categorical statement. I have no authority to give job. I have stated to her, my lord.
Okay.
That is job card to husband. Husband come with people with some money. He takes money. Ultimately, I thought that it will take my bad name, my lord. So I want him not to come with the people. That's why, my lord, he. That is the problem.
Mr. H.R. Learned Senior Advocate, assisted by Mr. A.M. Ahmed, the learned counsel for the petitioners, and also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section 482 of BNSS, praying for granting pre-arrest bill to the present accused petitioner. Post in the case, in connection with PS case number. It is submitted by Mr. Chaudhary, the learned senior advocate, that false and concocted allegations has been brought against the present accused petitioner only on the grudge, as he warned the husband of the informant not to come with various persons to his office for applying the job card. After registration of the, no, sorry, subcard first. Further, he submitted it from the plain reading of the FIR itself. It is seen that the informant slash victim herself visited to Hosai, telling lie in her family members, and thereafter she brought the allegation of committing rape on her by the accused petition, which is totally false and concocted one. Further, he submitted that after filing lodging of the FIR by the informant, her husband also lodged an FIR, which was subsequently treated as an which was treated as a subsequent FIR, and GD entry has been registered accordingly. Stop. Next para. Mr. Chaudhary further submitted that the accused petitioner is a 59-year person and he has not committed any such offense as well as in the FIR, and will appear before the investigating officer and will cooperate the investigation if he is granted with interim protection. Next para. Mr. Borwa, the learned additional PP, submitted in this regard that the CD may be called for, and from the FIR, in the FIR itself, he brought the FIR itself, the victim brought the allegation of committing rape on her, and hence the FIR will reveal the actual fact of the case. Next part, considering the entire facts and circumstances of this case, I find it a fit case to extend the privilege of interim pre-arrest bail to the present accused petitioner till the receipt of the case diary. Okay, will be under interim protection.
Obliged. He will
Appear before the learned, appear before the IO within 7 days, 1 week, and cooperate him in investigation. When it can?
8th of January.
8th of December.
January. CD call করবো 8 January. Make the difference.
Obliged.
Just for 5 minutes. 51. Along with
35 is CDs there, lots of is called for MP Goswami. So along with 35, lots is called for CDs there.
Oh, yes, yesterday you have submitted.
So along with that 35, lots of called at the time.
35 is dealing with Gusami.
Lots of.
Just for 5 minutes.
Bill hearing. Item 25.
This is a lordship. Well, in this case, I was arrested on 9/9/2022, my lord.
Scan copy you have received?
Yes, and I have also, my lord, lordship, I have also, my lord, that's up to date order sheet certificate of which I may be permitted to place before this court, man.
So you got arrested when?
My lord, I was arrested on 9/9/2022 and forwarded to judicial custody on 10/9/2022, my lord. I was a driver of a vehicle from where, my lord, contrabands amounting to commercial quantity was recovered, and thereafter, my lord, a charge sheet in this case was laid on 30/11/2022. Citing has been as 9 witnesses, my lord. 9 witnesses, and my lord, thereafter, my lord, charges were framed on 23/05/2023 against the present petitioner. I have annexed the framing of charges, my lord, order. And after that, my lord, on 4/7/2023, a supplementary charge sheet was laid in this case against another accused person, my lord, showing him as an absconder. Yes, and my lord, thereafter, my lord, although my lord, NBW was issued, till date, my lord, the matter is at appearance stage. Lordship will.
So till now, prior to the filing of the supplementary charges, was there any evidence recorded by the?
No, no, my lord.
Not yet,
Not yet.
till now.
Till now, well, it's not yet recorded. And in fact, my lord, the matter was last posted on 26/11/2024. That I have 26/11/2024, my lord. And I have that order sheet is also there, my lord, last page of that compilation, my lord. Lordship will find now the matter has been posted on 15/2/2025 for appearance. Lordship has got it, my lord. That is, I have obtained, my lord, from the e-codes. It is uploaded in the e-codes, my lord. My lord, still today I am in custody for 2 years, 2 months, 19 days. That is 811 days, my lord. And my lord, from the progress of this case, my lord, it is not it is, my lord, discernible that commencement of trial will take some reasonable time, my lord. So if considering the prolonged incarceration, my lord, my humble prayer before this honorable court is to consider the liberty of this present petitioner imposing any stringent condition, my lord. There is remote possibility of commencement of the trial, my lord.
The charge framed on 23/5/23 also. Because one accused person is absconding.
25/3.
23/5.
23/05/23, my lord.
One person, the Rajpal Singh Punia, he was still absconding, lordship. That's why framing of charge is delayed. The charge framed on 23/5/23.
No, but sir. The subsequent or supplementary charge sheet was filed on 4/7/23.
Yes, yes.
Prior to that, charge was framed against this petitioner, I think.
Lordship.
I have read both the orders, my lord. Next, sir, page 37 and 38 of my petition, lord.
There are 10 PWs, lordship.
9 orders.
9 and 10.
9 PW. 9 PWs, sir. 9 PWs. That is page 29. 29.
So, lordship, my humble prayer before your lordship that at least some witness should be examined at this stage, lordship. So at this stage of trial, lordship, the petitioner should not be granted bail, lordship. I may make the objection of granting bail because no witnesses are examined yet. The contraband was seized from his possession and from the track, lordship. 1108 grams of ganja.
Let's just refer to some of the judgments of our court. Madam, that page 11, madam, page 11. It is from our Honorable High Court, madam. In this case, my lord, although the petitioner was only behind the bar for, my lord has got it, lordship, page 11, madam. Yes, he was behind the bar for only, my lord, 1 year, 6 months. And on
This is from our page 11 is by Supreme Court, I think.
yes, my lord. My lord, our High Court rejected the bail application, my
Okay,
lord.
okay.
Against that, SLP was preferred. So he was, my lord, in custody for 1 year, 6 months only. And in this case, only 5 witnesses were enlisted in the charge sheet, my lord, 2 were examined. So, my lord, considering the period, Supreme Court granted, my lord, bail to the accused petitioner, my lord. And page number 13, my lord. 13 also I'm referring, my lord. These are very recent orders of the Honorable Supreme Court. This is also from our High Court, my lord, did not entertain the bail application, my lord. If I may just read, my lord, 2 paragraphs, small paragraphs, my lord. We are inclined to set aside the impugned order only on the premise that the trial is yet to begin and the appellant has been in incarceration for 17 months. Only 17 months, 1 year, 5 months is there, madam. Thus, on the principle of right to speedy trial, we are inclined to grant bail to the appellant. So, madam, in the present case, the petitioner is behind the bar for 2 years, 2 months, 19 days, madam. And there is, madam, a remote possibility of commencement of the trial, madam. So, considering this above aspect, madam, and another aspect, madam, he has no criminal antecedent, which in fact, my lord, number of orders Supreme Court has taken care of, and I have also annexed at page 3, my lord, in this compilation, page 4, my lord, paragraph 3, if I may allow paragraph 3. In this case, my lord, commercial quantity of ganja was recovered from a vehicle. The fact, my lord. I'll read the paragraph 3, my lord. It appears that some of the occupants of the Honda City, including so and so, have been released on regular. It is true that the quantity recovered from the petitioner is commercial in nature, and the provisions of section 37 of the Act may ordinarily be attracted. However, in absence of criminal antecedents and the fact that the petitioner is in custody for last 2.5 years, we are satisfied that the conditions of section 37 of the Act can be dispensed with at this stage, more so when the trial is yet to commence, though the charges have been framed. She has got money. So, Malad, these are the, in fact, Malad, in this case also, the petitioner has no criminal antecedent. He is behind the bar for 811 days, Malad. So, considering these above principles, Malad, right to speedy trial, and also, Malad, that he has no criminal antecedent, my bail fare at this stage may kindly be considered. I'm ready to furnish, Malad, any condition, will abide by any condition, Malad, any surety, if possible, if required, Malad, furnish government surety also. Malad.
Lordship, the petitioner is from Samastipur, Bihar.
Not with jurisdiction also.
One you have granted bail.
Yes, that is true. That is true.
Yes, but in that aspect, my lord, in similar page 24, where Lordship was occasion to deal with one such person, my lord, who was also from Bihar. So Lordship imposing stringent condition. In this case also, my lord, that person was behind the bar for 2 years. There was no probability of commencement of trial. So Lordship, upholding the personal liberty, granted him bail, my lord, imposing stringent condition. So in this case also, I pray for my lord, similar consideration. I will not leave the jurisdiction, my lord, without the leave of the honorable court, my lord.
This is true that lots of judgment and have a coordinate one also and supreme also lots of judgment are there.
Practical, there are some issues.
Some issues.
We can understand.
Going to the offenses and Indian offenses, looking to that. So I may be doctor oppose that comes.
Later on, you pass the order. Discuss.
Item 28.
It was item
28. This was 25.
20? Nice. It was 25?
Yes.
And 28.
My lord, petitioner was arrested on 10/1/2024. Today is about 323 days, lordship. Charge is submitted and LGR call for lordship. After receiving the LGR lordship, some more witnesses examined. So that status may be called for lordship.
The last status report was when? We have received the LCR, I mean, scan copy when?
PW fact, but last witness, he was examined on 26/7.
26/7.
Thereafter, lordship. Thereafter also some
Maybe
witnesses are examined, lordship, to our information also. So they are Caesar witnesses. If they have not implicated this person, then lordship make a decision for that. So lordship, and the person is suffering from severe diabetic, lordship. So that medical report may be called for from jail authority.
Hard MS Askanakis, still on counsel for the petitioner. And also hard Mr. You are who are you are appearing? Mr. DP Goswami, the learned additional PP. Also, it is submitted by Ms. Nargis that after receiving of the status report, as per their instructions, oblique information, some other witnesses are all been examined, and accordingly, she submitted that the present status report may be called for. Mr. Goswami, the learned additional PP, also submitted that as per the status report oblique the scan copy, the last witness was examined on 26/7/2024. Let updated case status report be called for as to whether any other witnesses being examined, and if so, the copy of the and if so, we detailed like a status, but I mean scan copy of the LCR with the present status report of the case committee.
Along with the deposition, if any recorded.
Yeah, along with the deposition, if any recorded. MS Nagis further submitted that the accused petitioner is also suffering from, is also a severe diabetic person, and accordingly she prayed to call for a medical report from the jail authority. He is in Central Jail Guwahati or
Golaghat.
Golaghat. Accordingly, a medical report may be called for from the superintendent of Golaghat Jail. This will be by the registry only. The registry will take the necessary steps in this regard. List accordingly. Yes, when it can be listed. Prior vacation may not be possible. After vacation,
First week of January.
first week of January. First week of January, any date can be given. 9
If
will do.
possible, can it be, because he is diabetic, can it be before vacation or last chance?
Before vacation.
As a last chance, lordship, or last days,
May not be, last date we cannot give.
or 19 or 18 like that, lordship. Let fix, if not, then again it will fix again. in the
At
month.
best 18 pura pare. At best 18.
18. 18th of December.
Yes.
Deeply blessed.
30.
Sir, maybe fix at 2 lordship.
Just a second here.
Service is completed, lordship. So data court and lordship and amicus may be appointed, lordship. No one is from the respondent side, lordship. Service is completed. It's a POCSO case, and we have received a case diary. Fix another, amicus can be appointed.
But whether notice was there.
Notice service completed.
Notice is
we have
served.
received notice served.
Lordship, he has an exam in the month of December, lordship. He's a college going boy student, lordship.
We have received the case diary also.
Lordship fixed at 2 lordship.
No, not fixed at all. She is insisting for appointing an
One-
amicus.
One thing, lordship, 164 statement of the 183, that statement separately is not in the case diary. It's just recorded only. In the as per the IO2, which is recorded, but not in the case diary. Okay.
164 will required.
Required also.
Then
We have to call for that 164 record also. I have gone to the case diary, lordship, but that is not in the case diary. But as per the IO note, yes, it's just recorded. So fix it on lordship. And it is from Khetri, it will not come. Look at it, yes. We have to be fixed on code and
no exam. Have you filed the schedule of the examination? Because no examination is there, I think, in the month of December.
Fixed on 5 lordship.
164 is required, lordship, it is true.
164 definitely. Why is 164 is
Not in the case diary, why? But it is recorded, lordship, going to the case. As far as IO note, it was taken on
recorded?
recorded. One eighty was there, okay, 160 on seven is there, but 164, so it is 183 at BNSS. That is not in the case diary.
You are MS?
M. Deca.
Hard MS M Deca for G Borua, appearing on behalf of MS G Bora. It is submitted by Mr. Kusami, the learned additional PP that CD received, but 164 statement of the victim is not available in the case diary, which is necessary to dispose of this bail petition. Further, he submitted that the notice has already duly served on the respondent number 2/victim plus informant. Accordingly, he prayed. And accordingly, he submitted that one amicus may be appointed to represent the respondent number 2. Can we appoint or registry will appoint? Registry. Registry is accordingly directed to appoint one amicus curiae to represent the respondent number 2 in the meantime. Let CD you want to retain?
Retain custody.
Uh,
Only call for a 160%.
let the 164 statement be called for from the IO. CD be retained till next date of listing. When it can be listed?
Lordship,
Huh?
5.
5 though may not possible. 5 is not possible. Can it be?
10, 12. All
10,
three.
5, 6, 10, there are also many matters are there in fact.
50, it's a BA lordship, 52 days in custody.
10, you want to 10? 10 or agot ki ase? Bondho niki? 10 or agot bondho niki 9 to? 9 can be done. 9 kori dibo. So in the month of December only we are fixing 9, 12. Let us see this.
31.
It was data. Yes. Yes.
482 application, my lord. Allegation against this petitioner is 0.22 grams heroin was seized from his residence, my lord. My lord, FSL was called for. Okay.
FSL report received by the way, it is positive, my lord. There is bail application, my lord. My lord, confirmed recovered from his position.
Only my lord 0.22 grams. My lord.
But anticipatory should not be there, I think. Otherwise, it's a small quantity. And 27 is also there. Most probably he used to consume. But anticipatory in NDPS is what do you want to say? Submit.
I oppose, my lord. But mother in NDPS case, my lord, it's a contraband, my lord. Sorry, my lord. Organized crime, my lord. And my lord. Secondly, my lord. So 29 is there, my lord. They are peddler, my lord. Initially, my lord, one, my lord, Rupu Seg was apprehended, my lord, and his possession, my lord, 8 gram heroin recovered, my lord. Then, my lord, he was interrogated. He has implicated this person. His house was also searched, my lord. And from his possession, my lord, 22 gram heroin recovered.
2.2 gram or
0.22.
0.22.
0.22. We heard Mr. M. Kalita, Dewan Counsel for the petition, and also heard Mr. R.J. Borwa, Dewan Additional PP, appearing on behalf of state respondent. This is an application under 482 so and so so and so. CD received, is received, heard both side. It is submitted by Mr. Kalita that accused petitioner is not a peddler but a consumer, and only 0.22 grams of heroin was recovered from his possession, which is much lesser than the small quantity. And accordingly, he submitted that petitioner accordingly paid for granting him pre-arrest bail, and submitted that he will appear before the IO as and when his appearance will be required. Post. Next para, Mr. Borwa, the learned additional PP submitted in this regard that the FSL reports the FSL report gave the positive taste of heroin, and that apart, the case is also registered under section 29 of the NDPS Act, and the present accused petitioner along with the others are the peddlers who stopped. Initially, one co-accused was arrested in connection with this case, and thereafter only the present petitioner was searched, and from his position, 0.22 gram of heroin was recovered. Accordingly, he raised objection and submitted that it is an organized crime and the anticipatory bail should not be granted. Considering the submission made by the learned counsel for both sides, other aspects of the matter, vis-a-vis the materials available in the case record, case diary, I do not find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. There is a query. It is rejected.
Okay.
32.
Third number is the case of POCSO, my service is completed.
You appear.
FIR Miller, page number 10 Miller.
Yes.
Not actually, whatever offense has been alleged, my lord, it did not occur. The family of the alleged victim, the girl, was very unhappy with the relationship. It's a consensual relationship, it is a romantic relationship. So then they went and filed the FIR, and the 164 has also been apparently recorded. But now I have been told that there is a discussion with the family to get them married after the girl turns 16. Maybe the updated CD will reflect that also. That's what I have received the instruction from the.
In that regard, whether they have filed any application, such kind of whatever, before the IO, as per your instruction? Regarding that settlement or if the parents.
I will take an instruction, one date may be given. Regard to that. But I have been informed that there is because the girl has not turned 18, my lord. Now they can marry them off. So but there is a discussion going on, and both the families have come to an agreement. One date, my lord, I will update your lordship.
Yes. Otherwise, you have received the case. Is
Case
that
that received, my lord, and that means up to date, my lord, up to 11/11, my lord.
it's up to date one only? Otherwise, up to date one.
Otherwise, up to date.
Then
It's 27, my lord. The recent development.
recent development is of 27.
No, like today is 29, sorry. But there is a recent development that
In
there is.
turn 27.
I don't know the date, but in the last 1 week, there is a development, my lord. So the CD may be updated.
In that case, too, you have to return back. If there is any development.
Updated case.
Updated case.
I will do.
Do you have any other instructions? No. Only court only. Okay. Heard Mr. A.W. Aman, the learned counsel for the petitioner. Also heard Mr. R.J. Chaudhary, the learned additional PP for the state response number 1, and MS R. Chaudhary for the amicus security for the response number 2. It is submitted by Mr. Aman that there are some recent development, and both the family members have agreed to for marriage between the accused and the victim when she turns to her marriageable age. And accordingly, he submitted that the updated case diary may be called for poster. In that, let's say, they return the case diary, and accordingly, the considering this also and so video, return case diary, updated case diary may be called for. It will return body. When you can be
Anytime before vacation.
Not before vacation, madam.
Before vacation.
After vacation. It will be very long run. Anytime before vacation, even on the second
before
last day.
vacation, how can we manage? Because there are all are preparing for before vacation.
Vacation starts from 22nd.
19 and 20 when are going to fix any matters. I mean, there will be some more matters will be there. I mean,
16,
motion
17
states.
any day, my lord. 15 days is enough.
7 January. 7.
That will be little bit long, my lord. Anytime
Little
before.
bit long is okay, but before vacation, it's not possible, I think.
As your lordship, please. Ma'am.
First week of January, any day, did you? 7. We are listing on 7.
My lord.
So, oh.
33.
No, it was material. No. It was oh, it says that 35. Actually.
33 case that is
33. Case diary received now. None appears on call for the petitioner. It is submitted by Mr. R.J. Borwa that CD has already been received. Written this CD. Written this CD. 11 of this month. Written this CD list accordingly on 11/12. We're listing it on 11/12.
11/12.
Yes.
34.
Yes.
Here the petitioner for your lordship is 23-year-old boy. He was having love affair with a girl lordship of above 16 years. And and thereafter lordship, the girl went to the house of the boy for getting married lordship. And as she has not attained the age of majority, the family members of the petitioner has returned her to her home. And therefore some dispute was there, therefore this FIR was lodged. But Lordship may kindly see the FIR that your Lordship will find page 8. There are some allegations which Lordship under POCSO Act Lordship, and service is complete in the present case, right? Probably my learned friend has appeared. And there was some relations admittedly, Lordship. Was one judgment of honor.
FIR is a bit,
That allegations are there. Therefore, I'm not submitting on that aspect. Lordship. I have already my client has instructed me that they have already settled the issue. That after attaining majority, they will solemnize their marriage. And Lordship may kindly see that page 14. I have enclosed one judgment of Rajasthan High Court. 14. 14. Rajasthan High Court. Similar issue was there. Minor was there. Pregnancy was there. And thereafter, Lordship, invoking section 482, that FIR was passed. Page 18, Lordship may see kindly that page 18, the observation in paragraph 18. And that order was challenged in Honorable Apex Court, which was dismissed, Lordship. Just I am handing over that copy, Lordship. In top portion, your Lordship will see that arising out of final and impugn order, his number is there, dated is there. And page 14, which I have enclosed, same. Lordship. Because here also that observation is there, even if that those are Lordship, page 19, serial number 7, Lordship may kindly see. Page 19, serial number 7. Top portion, Lordship.
yes.
Admittedly, Lordship, they are young boy and girl, Lordship, that in the judgment which I have cited, their boy was 22, girl was 16. Here boy is 23. So at least considering that those facts, Lordship, and considering the conflict will not be required in that case.
Yes, Gaurav.
Judgment is distinguishable from the factors circumstances of the present case, my lord. This case, my lord, the investigating officer, my lord, he has, my lord, sufficiently, my lord, collected materials against this, my lord, accused person, my lord. Because 164 victim is implicated him, my lord. And my lord, medical also, my lord, medical report also, my lord, goes against the, my lord, accused person. The material, my lord. Yeah, my lord, he is appearing for the amicus curiae.
Yes.
Oh, sorry, my lord, for the informant.
As per instruction of informant, there is a lab relation, my lord. But CD will reveal first.
No, CD is to reveal. Now, what is your submission?
Informant file, my lord, this case, my lord, as per rape was happened, my lord. That was, my lord, as per FIR, my lord.
What happened?
Rape, my lord, rape. What is the case, my lord?
Admittedly,
I'm not
there
just
was love.
very.
Yes, my lord. On date, my lord, 25/08/2024, my lord, when the informant was not in home, my lord, then my lord, rape was done by the accused, my lord. That is the case.
No, that is the case.
Yes.
What is your instruction?
Then, my lord, instruction, my lord, there is a love relation, my lord.
That is to there, but
yes.
other in remaining other aspects.
Others, my lord, that is number silent, my lord. Informant is silent. That, my lord, informant is silent, my lord, that, my lord, opposing the bail or not, my lord. But, my lord, instruction is that, my lord, there is a love relation between them. And when attaining majority, my lord, they will marry, my lord. That is.
That already in presence of village elderly people, they have settled that once he attains majority, marriage will be solemnized. That in fact, I have stated in
That 164 says otherwise.
yes, paragraph 4 of my petition, Lordship may kindly see, that is on record.
There is no Parabat money love story now.
paragraph 4 of my petition, Lordship, and this is page 3.
No, 64 is very bad.
That on merit, Lordship, I am not submitting that part, Lordship. And the judgment which I have referred, that also says, Lordship, if that prosecution continues, he will go to jail for sure. And considering the relationship and age of those people, Lordship, that affair was passed. And I'm not on passing, Lordship. I'm only on that custodial interrogation, Lordship. There were admittedly loved those I have stated in my paragraph 4, Lordship, and there was some dispute that they thought that I'm not going to marry the victim girl. Therefore, the present affair was lost. But it is already settled by the elderly people of the village, because those two young boy and girl lives are involved.
Heard Mr. A.M.A. Learned Counsel for the petitioner, and also heard Mr. R.J. Borwa, learned additional PP appearing on behalf of state respondent, and Mr. M. Kalita, the learned counsel appearing for the respondent number 2 of the informant. This is an application of section so and so in connection with so and so. City received, parents received, heard both sides. It is submitted by Mr. Ahmed, the counsel for the petitioner, that both the accused and the victim had the love relationship, and out of which the girl also insisted the accused to marry her, but as she was not attaining her majority, the accused as well as his family members refused to marry the victim, and on the date of alleged occurrence also, the family members of the accused petitioner sent her back with a promise that he will marry her as and when she attains the age of 18 years. But after 3 days of the said incident, the affair was lost by the informant. But after lodging of the FIR, there was an amicable settlement between the two families, and the boy is ready to, the accused is ready to marry the victim as and when she attains her age of majority. Next para. Mr. Borwa, the learned additional PP, submitted in this regard that there was sufficient incriminating materials against the present accused petitioner. More particularly in the statement made by the victim, she brought the allegation of rape against the present accused petitioner, and hence she raised objection and submitted that it is not a fit case to grant it the privilege of pre-arrest bail to the present accused petitioner. Next, from Mr. Kalita, the learned counsel for appearing on behalf of the, you are amicus, no? Appearing on behalf of the informant / respond number 2, submitted that from the instruction he received from the informant, it is a fact that both the accused and the victim had the love relationship, and the family members of both sides also agree for marriage between the victim and the informant. However, he as the in respect of the allegation of penetrative sexual assault, he has no instructions. Next paragraph, Mr. Ahmed further submitted that the accused petitioner is ready and willing to cooperate the IO in the investigation of this case. And he also relied on a decision of the Honorable
Page 14.
Pune High Court, Rajasthan.
Rajasthan High Court.
Honorable Rajasthan High Court, wherein this situation, wherein in a similarly situated situation, the learned, the Honorable High Court had paused the proceeding against the accused appellant.
Against that lordship, state went to Supreme Court.
No, and against which the state also went to Supreme Court, and the special SLP was dismissed by the Honorable Supreme Court. Next paragraph. Considering the entire submission made by the counsel for both sides, I find that one chance may be given to the present accused petitioner to appear before the IO and to cooperate in the investigation of this case. Accordingly, I find it a fit case to extend the privilege of interim period as well. List koribo, updated case diary kind list koribo on 9th of January. He will be remain under interim.
Lord.
My objection may be read.
Yes, I have already read.
Obliged, Lord.
Five along with 51.
First question, the BA may be taken also. BA 51.
51.
51. Yesterday also I have pointed that there is a discrepancy between FIR and lots of the forwarding report. Let me kindly see the FIR page 13 losses. Page 13 of my petition losses.
Item 51, page 13.
May the FIR loss.
No, you have read yesterday, two numbers were there,
Yes,
vehicle numbers.
The allegation is that lots of 3 numbers of vehicle suspectedly stolen cattle were carrying from Nagaon to Morigao district losses. 1 vehicle they have intercepted 6 numbers of cattle losses and 2 vehicles fled away. The incident took place losses on 16/10/2024 losses. Now the present petitioner losses, he is arrested on 27 losses. The same incident losses they have narrated the same vehicle losses, 2 vehicles. They have stated that losses on Jalugati, losses 2 vehicles they have signal to stop, but they have fled away losses. But they have not registered a case or on the said incident. Now the petitioner has been apprehended in the present case, which the case was registered on 16 losses. 33 days in custody losses. What
No,
happened?
1610, it was 1 vehicle was intercepted and 2 vehicle
Fled away losses.
fled away.
Fled away.
And then,
Now you also kindly see the forwarding report losses.
no, on the other
2 vehicles.
FIR, in the other FIR,
No, there is no any other fellowship. No other fellowship.
oh, only forwarding.
Only forwarding. Only forwarding. They have mentioned that
Page number?
Page number losses 16 losses. Page number 16 losses. Again, they have conducted Nakasing at Jalugati, same place losses. But that is different losses. Pay of not 3 losses. Pay of not 3 losses. During investigation, I along with staff started Nakasing at Jalugati Bazar. Earlier, the FIR 16, the Jalugati Bazar also. Jalugati Bazar on 27/10/2024 at 4 AM. On seeing the police team, 2 cattle loaded vehicle bearing registration number A01HC8905
A01PC 1183 were fled away at high speed. After that, we searched the vehicle in a Mikiveta Patwakota road. Finally, we were able to apprehend Mirazul Islam, so and so, to Zahirul Islam. But the vehicle were concealed by them at somewhere, taking the advantage of zigzag multiple. It is interesting that lawsuit, they are unable to apprehend the vehicle, but they have arrested the person's lawsuit. But they have not registered a case. To my instruction is that lawsuit, this FIR was registered on 16 lawsuit. They're randomly apprehending persons lawsuit. They are not connected with the instant FIR lawsuit. So basically the allegation is that lawsuit stolen cattle were carrying from Nagaon to Morigaon lawsuit.
Now, at the time of their apprehension, whether when they were apprehending, there was any seizure of cattle also?
No, lawsuit. No. They stated that lawsuit, they have apprehended a person, but the vehicle has concealed by them lawsuit. They seize the vehicle, but they are able to apprehend the person, but they are not unable to seize the vehicle as well as the cattle lawsuit. It's so interesting lawsuit. So my instruction is that lawsuit, this case was registered on 16 lawsuits. After that, they are randomly assessing the person's lawsuit. Because of lawsuits, to my understanding that the market, there are as many as 7 numbers of market running by the government itself in the Morigaon district lawsuit, to my instruction lawsuit. And if there are a market lawsuit, then if there is a market in the district lawsuit, there must seller and purchaser lawsuit. The seller and purchaser cannot be said that they are stealing cattle or they are smuggling cattle, etc., etc. lawsuit. The allegation, your lawsuit may kindly see the page number 16 lawsuit. The main allegation is that the suspected stolen cattle were carrying lawsuit. To my question to the learned PP, that if any whisper that they have stolen cattle from a specific person and that specific person's statement has been recorded and they have identified that this 6 numbers of cattle identified that said
No, just I want to.
lawsuit.
On seeing the police team, 2 cattle loaded vehicles bearing so and so were fled away in high speed.
Lawsuit.
And they chased the vehicle.
Yes.
Although it was they able to hide it somewhere.
Yes.
And the accused were
apprehended.
But what about the cattle?
No, lawsuit. This person is nowhere connected with the present affair.
No.
Even
it is written that the loaded with cattle.
Yes.
The cattle were not there.
No, lawsuit. It is just made up by police law. This story is made up by the police lawsuit. This person is nowhere connected with the state offense. He is just, to my understanding, the broker of the market lawsuit. He take cattle from the owner lawsuit, some leather places, and sell it to some higher prices lawsuit. That is his business lawsuit. And now he is booked under the state offense lawsuit. Where the allegation is that stolen cattle were.
Since when he is in custody?
Lawsuit, he was arrested on 27 lawsuits and is on the 33 days in custody lawsuit.
What about the other case?
The other case is also same lawsuit. They are also there are some forwarding report lawsuits. FIR same lawsuit. If forwarding report your lawsuit may kindly see.
No, it's a AB, I think.
AB
Other
lawsuit.
one?
AB lawsuit.
Yes.
Page number 17 lawsuit. Page number 17. Lawsuit para 11 lawsuit. The co-accused persons, the main gang leaders of the complete cattle smuggler racket. They have put some name lawsuits.
So you are one of them.
No, lawsuit. 2 persons named in the here lawsuits. One the Heroin lawsuit. Petitioner number. No. So Sadarul Haq lawsuit. Petition number 1 lawsuit. In CL number lawsuit. Zahirul Islam, he has already been arrested lawsuit. Now lawsuit the Zahirul lawsuit will find at page CL number 3 lawsuit. Sadarul Haq lawsuit. Petition number 1 lawsuit.
This Sadarul Haq, Nur Alam and
lawsuit the other name was
Yasiki.
not there. Lawsuit Nur Alam.
Altogether 4 petitions are here.
Yes, lawsuit. 4 petitioner lawsuit. That would here Zahirul already arrested lawsuits. Now before your lawsuits. 2 Nur Alam lawsuits and 3 Sadarul Haq, petition number 1 lawsuits. And 4 lawsuits Bapoti and 5 Adat. To book under section 13 of the Assam Cattle Preservation Act lawsuit, one has to violate section 4, 5, 6, 7, 8 lawsuit. What offense they have committed lawsuit?
Yes.
Lawsuit will find first, my lord, that it is a organized scheme. This is not unlike the other cases, my lord.
just taking the goods, and the lordship will find from the FIR, my lord. First, the lordship will find from the FIR that there are 3 vehicles involved, my lord.
Yes.
At the committee of day, my lord. Thereafter, Naka checking was conducted, and out of them, my lord, 1 vehicle could be apprehended, others fled away, my lord. So the search is on for the other vehicles, my lord. That is where, my lord, and again on 27/10, my lord, when the Jehul has been arrested, my lord. On 27/10, again Naka checking was getting an information, my lord. Then again, my lord, Naka checking was they established for apprehending these vehicles, my lord. There, my lord, when 27/7, when they came, my lord, police seized them vehicles, my lord. What they are doing, my lord, the mothers is, my lord, they are shifting the cows from one place to another place. This has come out from the investigation, my lord. So what they are doing, my lord, with the 2 vehicles, my lord, they are shifting to some other places. And that time the police has, my lord, intercepted them. They were chased, my lord. And first day, the vehicle that is why, my lord, why the vehicles were not apprehended, my lord. First vehicles, my lord, could not be apprehended because the cattle were there, my lord. First, they, my lord, led the vehicles to other places, and accordingly, this petitioner is arrested, my lord.
No, other places mean?
They have concealed
No,
the
no, you are
vehicles.
saying that they used to shift the
Vehicles, my lord.
cattle.
That is why, my lord, it is not clear whether this vehicle contains, my lord, not only these 2 petitioners, there are other petitioners who are driving the vehicles, my lord. It's a, my lord, to, my lord, mislead the investigation process, to mislead the police, my lord. So what they do, my lord, the vehicle, that is why, my lord, in all cases, your lordship will find in these other cases also, vehicles could not be intercepted, my lord, because my lord, the vehicles are my lord, more important than their, my lord, person, my lord. That is what.
Yes, that is my question, Lord.
That
Vehicle
is-
is more important, Lord.
that is-
But they fail to apprehend the
That-
vehicle. Okay.
That is why, my lord, they are trying to, my lord, hide those cattle and the vehicles, my lord, and they were apprehended, my lord. On 27/10, he was apprehended, and from his, my lord, interrogation, my lord, several things has come out, my lord. He is one of the prime accused, my lord. He is leading the, my lord, the cattle from one places, and that is used to be transferred to, my lord, road through, my lord, Meghalaya, my lord. And your lordship will find, my lord, from equality, my lord, in the Cattle Preservation Act, interstate transfer is barred, my lord. You cannot just shift the vehicle from one cattle from one place to another without the authorities' manner certificates. So what they do, manner, from the Jehirul manner, his statement manner, several things were, my lord, has come out, my lord, and from his, my lord, confession, some other accused are also arrested, my lord. But, and from his statement, it is found that, my lord, the cattle which were yet to be recovered from those 2 vehicles, my lord, these were, my lord, with the 4 persons who were yet to be arrested. That is in item number that is 35. A detailed bail objections has been, my lord, given by the IO, my lord. You may kindly take it up, this objection. You may kindly take up the bail objection.
Yes.
And your lordship, another thing, my lord, in the forwarding, my lord, your lordship will find in a page 16, my lord, they will, the last point number 10, my lord. They are habitual offenders because your lordship will find.
16, page number.
Yes, my lord. In the earlier case, I have failed to point out, my lord. Page 16, that is forwarding, my lord. Page 10, point number 10, your lordship will find. They, in the course of inquiry, it is learned that vehicle previously used along with stolen cars is.
No, in page number 10, in which
My lord, the BA, my lord. That is my
page
item
number?
51.
Page number?
Page 16, that is the, my lord, forwarding.
Forwarding,
part.
yes.
Yes, that is, that I have skipped, my lord. They are habitual offenders, my lord. Their antecedents are there. My lordship will find from the last point. It is learned that vehicle previously seized along with stolen cars in connection with Morigao PS case. Was also required under, in connection with Morigao PS case also, my lord. So their antecedents are there, madam.
No, this
Now,
vehicle
my
not
lord,
belong to the present petitioner also.
now,
And the vehicle maybe is an earlier occasion also, but
Now,
how
my-
this present petitioner is connected with the said vehicle?
now your lordship will find that kindly take up the minor, the bail objection. Investigation is required to be done now. Your lordship will find minor, the stolen articles along in the page minor, in the second page of the bail objection. Your lordship will find in the below minor stolen articles which were yet to be recovered minor. It is specifically given stolen articles, stolen cattle which were loaded in the vehicles bearing registration number such and such. The cattle is in custody of these 4 persons minor. Yes, and thereafter minor, 4 numbers of stolen cattle loaded in Bolero pickup, such and such, and 3 other vehicles which are concealed by again these 4 petitioners. These has come out from the interrogation of 5 accused arrested till now, minor. They are all in an organized way carrying this minor crime, minor. And your lordship will found in the
Cattle
next.
business is very profitable, I think.
Yes, man, very, very profitable because what I have learned, my lord, once they cross the border, my lord, it was, my lord, more than, my lord, 4 or 5 times more than they get the
original
price,
actual price.
my lord. Because then they used to, my lord, transfer it to Bangladesh because Bangladesh is the, my lord, highest exporter of beef, my lord.
Yes.
There is a border BSF.
Even to Meghalaya also.
Yes, Meghalaya, then to Bangladesh.
Then to.
My lord. So
My submission is that
now,
I
my lord,
found in other matters also they are
yes,
trying
yes,
to
my lord.
through that route only to Bangladesh.
And so and your lordship, therefore your lordship will see the next page in the bail objection lordship. When why this NACA checking is conducted again and again, madam. Your lordship will find the investigation cases still pending as a lordship's lordship, madam. Still pending for recovery of the remaining stolen cattle. And as such, during investigation on again 13/11/2024 at 2:30 AM, madam, again NACA checking was conducted. And we received from reliable source that 4 Bolero pickup vehicles with loaded stolen cattle are going to change their hiding location at Jaluguti by 5 veteran criminals. These names are there, my lord. They are all listed, my lord, in the petitioner in the my lord AB, my lord. This, my lord, Noor Alam, then again Yusuf Ali, Saifuddin, all 4 are their name. And hence we arrived there and started NACA checking. On seeing police team, 4 cattle loaded vehicles and 3 were fled away at high speed. After that, we chased the vehicles at Mikilgaon, Patakwa Road. Finally, we were able to arrest Ayub Ali. But the vehicles have concealed by 4 others, my lord. This is what they're going on, my lord. There are more than, my lord, 5-6 persons arrested, and they are also yet to be arrested, my lord. So, my lord, though, my lord, they are in the more than 30 days in custody, my lord. And your lordship will find from the CD, my lord, on his interrogation and on his leading, my lord, several evidences must come out, my lord. So the joint interrogation of the persons who are yet to be arrested and they are has to be, my lord, as per the, my lord, CD, my lord. At this stage, my lord, they may not be enlarged on bail, my lord. And your lordship may kindly see that all the, and your lordship also see the page. Last but second, lordship, the bail objection. There are several others also. The lordship may kindly go. In course of inquiry, my lordship, in the point 11, point number 12, in course of inquiry, it is learned that the vehicle registration number such and such previously seized along with stolen cows in connection with Morigaon PS case number such and such, and vehicle number 8905 previously seized along with stolen cows in connection with Morigaon PS case number such and such, Assam, which is owned by accused Zahirul Islam, madam. So Zahirul lordship may kindly see in other 2 cases also from his vehicle this stolen cows were recovered, madam. And therefore point number 17, your lordship see maximum numbers of cattle are transported to Bangladesh via Nelly, Karbi Anglong, Meghalaya for the vehicles which is loaded by Siradul, Uradam, Asik Ali, Saifuddin. They are all, my lord, petitioners in the AB, my lord. So their materials are very much, there are surplus of materials against them in the city manner, carrying out this smuggling manner of cows manner. So at this stage manner, they may not be released manner.
My
And their
submission,
interrogation is required manner, joint interrogation is required manner.
my submission is that lawsuit. They are
The
very much
lawsuit may
stating
like
that the stolen cattle lawsuit. Is there any whisper that this person has stole cattle from a specific person and that specific person statement has been recorded in the case diary lawsuit?
And whether they could
But
give any
the egg
documents
lawsuit,
manner.
some cattle preservation act, there is not mentioned.
Whether
The
they
cattle is
could
my
give any-
word lawsuit. Your lawsuit may kindly see if
And why
section
was
13 comes only lawsuit when section 4, 5, 6, 7 and 8 violate lawsuit. So what provision they have violated? The market is running by the government, they are taking revenue lawsuit. The moment they have purchased the cattle from the market and transported them, offense come out lawsuit. They are saying that lawsuit stolen cattle, there should be specific lawsuit. Which person they have stolen the cattle lawsuit? Is there any statement is there that recovered cattle has been belong to that specific person lawsuit? Is there any statement that the cattle has been stolen from that person lawsuit? There's nothing lawsuut.
Whether there
One case is registered.
In
Not,
that case, madam, whether any documents have been annexed by him, that they.
I am not owner even.
He is the.
If I am owner,
Why
definitely I
were-
will have
why
annexed the
were-
cattle
how
process
can
receipt lawsuit.
his vehicle is used in all these cases then, madam? In all other cases, only his vehicle is
The
apprehended.
transportation
madam.
cattle is not an offense. It's permitted by the law.
And your lawsuit.
Transportation, your lawsuit may kindly see section 7, subsection 6 lawsuit. Transportation permitted by this Assam Cattle Preservation Law. Your lawsuit may kindly see section 4, 5, 6, 7. Your lawsuit kindly see.
And your lawsuit
Transportation
cannot
are prohibited.
ignore, madam, cannot ignore the statements made by co-accused at the state of, at the time of my lord, taking the bail applications, my lord. The lawsuit has been cleared by the, my lord,
No,
in this, several cases in the, my lord.
Lawsuit may kindly see section 7, subsection 6 lawsuit.
You can
Section
not
section
ignore the
7,
statements
5.
made in the city, my lord, by the co-accused, my lord. That
No,
all
let
those
them,
cows are
let
hidden
them,
by
they
the.
specific. It should be specific. From whom they have stolen the
Very
cattle
much
lawsuit.
specific, it is very much specific.
No, from whom they have stolen the cattle. This is necessary lawsuit.
If your lordship may kindly see, madam. What the value 161 carries in the, at the time of investigation.
Lawsuit, okay, section 7, subsection 5 lawsuit. The cattle shall be transported. Lawsuit may kindly see the note. The cattle shall be transported in the manner prescribed by the central government rules governing the transport of cattle under the
Okay,
Prevention of Cruelty to Animals Act lawsuit. Suppose they have violated the transportation rule lawsuit. It's come under section 11D lawsuit. It's a bailable offense lawsuit. They're saying the cattle is smuggling, but there is no any specific person that the cattle has been stolen from that specific person lawsuit. No any whisper lawsuit. They're just saying the stolen cattle, but the case diary reveals no person that cattle has been stolen from a lawsuit. No statement has been recorded that the cattle has been of the said person lawsuit. There is something more than 33 days in custody lawsuit. To attack section 317 and there has to someone lawsuit that the cattle has been stolen from that person lawsuit. Section 379 is a red lawsuit. And to book under section 13 Assam Cattle Preservation Act lawsuit, someone has to violate section 4, 5, 6, 7 of which provision they have violated lawsuit. And to attack under section 379 lawsuit, there has to be some third party that the cattle has been stolen from that person lawsuit. So which section they have violated lawsuit? That's my submission lawsuit. How will I lawsuit? You know, lawsuit may kindly see also section 7, subsection 5 lawsuit. How will I lawsuit? May I please lawsuit? I beg to mention item number 38 lordship. I have filed 18 objection, but it was not in track with record. So kindly allow to call for lordship.
38.
38. I have filed objection, but it was not tagged with record.
I don't know. পাৰিব জানো এতিয়া
Objection, section number 1 কৰিব।
কৰিব কৈছে আহিব জানো এতিয়া we'll try
How like this?
38 na
38 lord.
petitioner, it was a leave petition.
Leave petition lord.
Petitioner Mr. E.S. Borkoma paid for an adjournment. Prayer allowed next week or
Next week lordship.
least after 1 week.
How like this?
Item 36.
May I please your lordship, anticipatory bail application lordship, petitioner before your lordship is 72 years old ailing person lordship. Let's see what happened in this case lordship. A carcass of the wild animal found in my paddy field lordship. That is why a notice has been issued against me, the call for the investigation lordship. This is the allegation against me lordship, that this carcass of the wild elephant found in my paddy field lordship. Your lordship, offense report will find page number 11 lordship. On last occasion, report was called for lordship. May I read the offense report lordship? Page number 11, got lordship. Yes, may I read it?
Yes.
With reference to the subject cited above, I have the honor to inform you that a carcass of the dead wild elephant male is detected by anti-deportation squad member from Borsala area under Dhekiyajuli range jurisdiction on dated 7/11/24 at Borbhogia, Borsala area at about so and so and GPS coordinate so and so. After he informed to our Dhekiyajuli range staff. The undersigned, along with the range staff, immediately visited the site for physical verification at 7:26 AM. After verification of the incident, we have found that the carcass was lying on paddy field, and the paddy field landowner is Kesar Bahadur Setri. This is the lordship petitioner before lordship. And so and so and so and so. In that time, we have also detected the paddy field is surrounded by the electric fencing. The postmortem is conducted on the same day at about so and so and on the same day, and presence of the undersigned veterinary officers, staffs, and other non-officials member. I would like to bring you the kind notice that an offense report so and so and so and is registered under section 9 and 51 of the Wildlife Protection Act at the office of the Range Forest Dhekiyajuli. This is the allegation lordship. But in fact, I have stated in my paragraph number 5 lordship that yes, I am the owner of this paddy field, but this paddy field I have given to the cultivate on the basis of the article lordship. Adhere to the one that person namely yes, also 1%. This is namely Dimapuria, residents of the block. Lordship, in this case, notice has been served under section 50 of the 8 against me, and I may be directed to appear before the investigation officer. I am apprehension of the arrest, lordship. That is why I will appear before the investigation officers. I may be protected, and I am 72 years old. I will cooperate with the all investigations of this. This is my case, lordship.
Yes, what?
May not be required, but cooperation is necessary to at least ascertain how the elephant ended up in that paddy field. So, lordship, that can be ensured. Case diary can be called for, interim can be given, lordship.
No, but in regards to notice, have you furnished any notice to him for appearing?
Yes, yes, lordship. Yeah, yes, lordship. Your lordship will find the page number 12, lordship. Yes. Annex B, page number 12, lordship. This is the notice. Someone to require attendance of the witnesses for the purpose of the investigation under section 58C of the Wildlife Protection Act 1974.
You are Mr. Borwa.
R. Borwa.
Heard Mr. R. Borwa, the learned counsel for the petitioner, and also heard Mr. I. Botapur. I'll be on behalf or
On behalf of Special PP Wildlife D. Gogol.
on behalf of Special PP Wildlife D. Gogol. This is an application. Under section 286, paying for planting and repair in connection with so and so, so and so, so and so. It is submitted by Mr. Borwa, the learned counsel for the petitioner, that it is an admitted fact that one carcass was found in his paddy field and pedophile during pedophile. Thereafter, which was seized and recovered by the forest department. But the field which was, but the seed pedophile was given to Adi by given to Kakis. To whom it was given? Adi.
One Dimapuria, residents of block 4, Phata Simolu.
Where it is mentioned? Where it is mentioned? In para?
Para 5, Lordship.
Page number 4.
Given Adi to 1. Dimapuria is here only para 5. Huh? You can see Dimapuria, resident of block 4, Phata Himolu, PS Koda. And he is not at all involved in the alleged offense, even if the elephant was died due to electrocution. But he is ready and willing to appear before the investigating officer and to cooperate him in the investigation of this case. He already received a section notice under section 50 of the subsection 8, small b, small c of the Wildlife Record Protection Act 1972. But as there is an apprehension of arrest, he could not appear before the investigating officer. Next para, Mr. Botako, the learned counsel for the department concerned, it is submitted that his cooperation will be required to investigate the matter, and accordingly he submitted that he may be directed to cooperate the investigation of this case. Next para, considering this submission made by learning counsel for both sides, I find it a fit case to extend the privilege of interim pre-arrest bail to the present accused petitioner till the receipt of the offense report. It is offense report is already there now.
Offense report is there. Case diary may be called for.
Maybe they call for the case diary till the receipt of the case diary, and in the event of arrest, there will be within 7 days. Within 7 days will be appear.
That's it, man. 10 days. 10 days.
Within 10 days, he will appear and cooperate the IVPS. But if the conditions are there, you put the conditions. Okay, you are the interim. And we are fixing it on, yes, Botakurani.
Any date in January?
January. 20.
Deep knowledge. Deep knowledge.
55 of the supplemental list.
Let me be lost. This is an unfortunate case, Lordship. All the evidence, Lordship, are in favor of the petitioner, but he is still behind the bar for 190 days, Lordship. A lot.
In favor of the petitioner.
My lord, in favor of the petitioner. That is, your Lordship, I will find PW1, page 23, and 164 statement that has also been annexed. Page 23, Lordship. Your Lordship has
23.
23. Victim statement.
Yes.
Lordship, your Lordship may come to page 24. In chief, also that is also favor in your cross. Your Lordship will find page 24. I have stated to police that I was having love affairs relationship with the accused for about 3 years prior to the date of occurrence. On the date of incident, I rang up the accused and asked him to come to so and so. And there, from there, I went along with him in bus to Guwahati, and accused did not force me to go with him, but I voluntarily went with him. It is not a fact that I have not stated in my 164 CRPC statement that after I went with Kolulur to Guwahati and stayed with him, then accused committed trap upon me. It is a fact that I have stated in my 164 statement that the accused is innocent and that I went with the accused on my own will. Lordship, 164 statement page 31. 31. Sorry, Lordship, we are page 28. My name is Supriya Khatun and my age is so I have love affair with a boy named Khalilur Rahman. I have done sexual intercourse with him one time with my own consent. One day, my mother beaten me badly, and so I, on my own will, went with him in Guwahati. My parents gave case, and so we returned home. He is innocent. And after the evidence of lordship examined the evidence of PW 1 and 2, lordship, a bail application was filed that was rejected, page 31, lordship, by the trial court, lordship. Here, lordship, in the meantime, charge sheet has been submitted, and till date, the complainant and victim has already been examined. Thereafter, also, lordship, the bail has not been considered. My lord, 190 days, lordship, 190 days. I am behind the bar, lordship. Considering, lordship, this aspect, lordship, he may be enlarged on bail, lordship. My lord, there is no possibility of any tampering, hampering of evidence, because main evidence has already been examined, lordship. Has already been. My lord, he is a young boy of 24 years, lordship. Young boy of 24 years, lordship, behind the bar.
Whether service complete or not, my lord, it has to be seen.
That on the last occasion, lordship, I have given that copy. That copy was served as per earlier order, and on that day, lordship, day before yesterday, your lordship was asked to obtain instructions. Again, he is saying same thing. I have taken a step. He has endorsed my step, lordship. But as the evidence has already been, lordship, done, lordship, your lordship may consider this 190 days, lordship.
Okay. Want to take any instruction now?
I don't think so, no, because as per law, it is required. That is what I am saying. Whether
Several times, lordship,
information is received or not, or
Can you do you have any way to take the
just
instruction
wait
at
for-
present?
if within the course of the day, if I found my lord, I will make a call.
Let before rising of this court, lordship, in the first half,
Because
I
without
also intimated
without
that.
the notice being completed, my lord, the case cannot be taken. That is a problem.
But here notice is given.
Actually, the matter was listed on day before yesterday, I think.
Yes.
So today was that day with the instructions too.
We had given the message also, my lord, for producing the report, my lord. It is not there in the copy, man. I will take the instruction. That it has come to office or not.
Today only it can.
Today, if it is there, my lord,
You
it can
try,
be-
okay.
Yeah. Otherwise,
After 10 minutes, lordship.
10 minutes may not be possible for him. Let us see. Otherwise, your part I have already heard. Let us take it.
Yes.
56.
Status report is also called for, my lord. Whether it comes.
Record may not require. I have already, lordship, annexed all those record, lordship.
Title number 56.
Anyway.
56.
See.
Yes, yes.
My lord, this case, my lord, the lordship had that passed that order, my lord, Hemen Rava, my lord. The lordship had allowed his bail, my lord. And here, my lord, I am a manager of him, of one of the company owned by Hemen Rava. I am the manager, my lord. And in the affidavit they have filed, my lord, they have categorically stated that I stood as a witness in some of the agreement. That is there in their affidavit. And my lord, the length of detention today is, my lord, 63 days, my lord. And the order passed by your lordship, my lord, at paragraph paragraph 16, my lord. There is a, my lord, in this regard to the merit of the case, it is submitted by Haloy that an amount of rupees 24 crores was misappropriated by the present accused petitioner, that is Hemen Rava. And the money was lying in his personal account in various bank accounts, and all the accounts have been freezed during the investigation. This is the order. This was the order. And the owner, my lord, already got bail. And you know, one small submission, and one more, my lord. In their affidavit, they have stated, my lord, that Hemen Rava, my lord, had two companies, my lord, where this misappropriation took place, my lord. Whereas I am a manager in another company, my lord, which I have annexed, my lord, in my petition at page 17, my lord.
No, you're saying that you are not the manager in the one company, in one company.
Of those two companies.
You are not the manager.
No, madam. I am the manager in a different company, madam.
Not under the Hemen Rava, not under Hemen Rava.
Under Hemen Rava, there are 3-4 companies, my lord.
Acha.
And the misappropriation took place in two other companies, my lord, that they have stated in the affidavit, my lord. But I am the manager of another company, my lord. But they stated, my lord, this collecting of money from public was done by Genie Capitals and Upethip Holding Private Limited. Whereas, my lord, I am a manager, my lord, I have annexed at page 17, my lord, of my petition that I am a manager of SMC company. Page 7. That much, my lord, and your lordship had already in that order, lordship had discussed all the laws, my lord. Same.
Perhaps he's claiming parity. Lordship, length of detention, lordship, already in that case, lordship, it is not 84 days. Here it's not, lordship. So on that ground, parity cannot be, he cannot claim parity, lordship. First thing. Secondly, lordship, his submission is that he is not the manager, lordship. So lordship sees the case that he will reveal that he is the manager, and it is he who induced the accused public to deposit money in Guinea Capitals and Upethis Holding Private Limited. He is the main accused here in this case. Though Hemen Rava is in conspiracy with Hemen Rava, is collecting money. So, submission of the counsel of the petitioner is that 409 is not applicable, but 120B is there, where the punishment is equivalent to the punishment is there in 409. If I'm not wrong,
120B.
120B is there.
120B9. 120. Subject to correction of 120B is not there.
120B was not there.
Is not there. Your lordship's order, my lord, I have given just now.
I'll see.
Second page, my lord.
I'm sorry, lordship. I apologize, lordship. Is applicable to him also because money has been transferred initially to the account of Hemen Rava and thereafter it's been misappropriated by both these accused persons. So the CD will reveal all the facts with regard to the role of this accused person. He signed as a witness to all the agreement which has been executed by Hemen Rava with the depositors, lordship. Him who, lordship, convinced the public to deposit money in these two company, lordship, which are not registered even. These two companies are not registered company. In spite of that, it is this accused person who induced public to believe that it is a registered company and if they invest money in that company, they will get benefit, lordship. And therefore, after signing the agreement, he stood as a witness, lordship. So therefore, materials are there against him, lordship. So, and the initial stage of investigation, only 63 days he is behind the bar, lordship. And we are going to file the charge sheet very soon, lordship. Before expiry of 90 days, we are going to file that. Therefore, my
now how 409 is affected? You're saying that he was one of the signatory in the agreement?
Yes, he's one of the signatories.
As a witness.
As a witness. And lordship, your lordship will see the statement of witnesses, which will reveal the fact that it is this accused person who induced the other person, public, to deposit money. And
Investment.
when the, yes, and when the money was deposited in the account of Hemendra, it has been misappropriated, Lordship. So even though if it is correct, Lordship, that 120B is not there, but if your Lordship sees the evidence on record, it will clear that the offense of 409 has been committed in conspiracy with this accused person. So finally, Lordship, we are going to file submission section 120B also, and 409 is already there, Lordship. So therefore, at this stage, Lordship, we are going to file the charge sheet very soon, Lordship, even before the expiry of 90 days, Lordship. Therefore, on my humble submission, Lordship, at this stage, it should not be released on bail. And with regard to the other parts of the law regarding the law point and all, already I have apprised this honorable court. Perhaps he is not also taking those point with regard to section 3 of GSP Act and all, Lordship. So he is on parity, Lordship. My humble submission, parity is not applicable in this case, and therefore his bail application should be rejected. Stand of both the accused are different, Lordship. And parity cannot be a, Lordship, there's two Supreme Court rulings also, but parity cannot be claimed as a matter of right. It differs from case to case, Lordship, with regard to bail. So therefore, Lordship, my humble submission, at this stage at least, he should not be released on bail. That's my expectation. If you Lordship, once Lordship, all the relevant entries.
Marked it.
Yes, yes. All the relevant entries which Lordship indicate his involvement in this case. We have narrated, Lordship, by flag marking all the relevant statement of witnesses, Lordship. These are the relevant statement of witnesses which will reflect the fact that he is the person who induced the people to believe that these two company, those two companies neither registered under RBI nor SEBI, Lordship. It's a completely Lordship illegal company who is running inducing people to invest money in that company, Lordship. And after investment of money, Lordship, they are not returning also to the. If your Lordship read the evidence of these witnesses, Lordship, they are taking the money but not returning it. So likewise, Lordship, they have misappropriated by both the accused, Hemendra and himself. Basically, Lordship, if your Lordship see the statement, this statement of these witnesses, Lordship, he promised this accused person who induced and make the people to invest money, and thereafter the money was not given to the person who has invested, Lordship. He is the person. Lordship may kindly have a look into the statement of witnesses.
My submission is limited, my lord. I am not the manager of those two companies. I work in a different company, my lord. And after all, my lord, I am the servant of that Hemendra, my lord, as a manager, my lord. And his submission in that case, my lord, he stated, my lord, he had made a submission that the amount of 24 crores is lying in that Hemendra's account, not me, my lord. That was submission, my lord, lordship is. That's God. Meeting of mine 409, where it comes, my lord.
120B is there. Lordship will find. 120B is not there in the
Yeah.
FIR. Lordship, at the time of registration FIR, we cannot, Lordship, hold that these are the section, Lordship. During investigation, this thing just come on light, Lordship. Definitely will file search under 120B.
That is what kind of submission, my lord? They are going to add 120B, so I should be kept behind.
No.
Is this a submission, my lord? One should be fair, my lord. We are also on the other side.
Fairly submitting.
We also
the
know that.
material on record.
120B he is going to add, my lord. Therefore, I should be kept behind the bars. How can it be, my lord?
Gravity of the offense has to be looked into, Lordship. Gravity of the offense, Lordship. It's an economic offense, Lordship. Time and again, Supreme Court is saying, Lordship, with regard to the gravity of the offense. It's an economic offense, which is a class apart, Lordship. Lordship, FIR is not an encyclopedia, Lordship. These things just come during investigation, Lordship. What is the role of this accused person? What is the role of other accused person, Lordship? Many other accused person may also come in life during investigation, Lordship. Well, those things, Lordship, we are investigating and finally we will file the charge sheet, Lordship.
Okay, I'll go to register.
I will bet.
Hello.
ND 55.
55, my lord, no record there, my lord. So, my lord, the wait for time till Tuesday, my lord. Again, serve the, my lord, because it is not there in the office also. I have now contacted my lord, they said that they will serve it, my lord.
Obviously, as there is an the order of,
Yes, yes.
so
Only that-
we have to comply
yes,
with, but
yes.
otherwise, as he has submitted,
Otherwise
most
also, my lord,
probably
it
the
is not that, my lord, he is entitled for bail on the basis of the merit, my lord. Because, my lord, if it is seen, my lord, by saving the victim, by saving the accused person, my lord, actually, my lord, she is implicating, my lord. Why I am saying so, my lord? He said that they have, my lord, the lordship will find from the statement of the 164.
she had,
and
yes.
She had sexual intercourse with her out of her own will, my lord. That itself, my lord, will not save him because her consent is no consent, and she has admitted that there is intercourse. In a way, she is again implicating him, my lord. Because that, then now, my lord, if that has to be believed, my lord, then POCSO 4 is implicated, my lord.
That will take it that final
Yes,
judgment.
that
of
is
the-
because on merit, what I have, my lord, when is saying, so I am, my lord.
No, he wants to say that the victim and the most probably one other witness has already been examined.
Yes, ma'am.
They are not implicating, so probability of hampering or tampering may not be there. That much most probably is sufficient.
Is same, my lord.
Mm.
It is.
Yes, almost.
Yes, that is my. But so, my lord, that part your lordship may
190
consider,
days.
my lord. Otherwise, because
Just to observe the formalities
Yes,
only, I
just
just.
to observe.
But this person lordship is suffering lordship.
Yes, obviously
Use
that can
days
be.
lordship 190 days.
He will. You have to be there.
Because,
And
of course, he has to, my lord.
Only because of this lordship. In fact, their part has already been done in the trial. What they will say before this court. Only because of this technicality. Well, this petitioner lordship 24 years
He
young.
is the age of 24 years. The girl victim, my lord, she is
16 years.
She is a minor, my lord. The 15 years, my lord, as per. So she cannot make his own right.
But there are some issues. I have already raised the issues before we had a conference in the National Judicial Academy, in fact. So I raised this issue because there are some categories there has to be there in the POCSO also. Because we see that sometimes the girl is of 16, 17 and boy may be of 19, 20, 21.
Yes. Just
But
above measure.
Just above
Yes,
measure,
that's
and
yes,
she
yes.
is also
Lordship
the
is correct.
consenting
Yes.
party and all.
Yes, yes.
Got
Yes.
eloped and
Yes.
get married also. There are some
Some.
instances. But yes,
Yes.
below 12 years, there should be one category. And
Yes, yes.
that is there. Most probably the issue might have been taken by the legislature also. There, if there is something, because yes, because otherwise Section 4 and Section 6, obviously it will come under Section 6 then. The Section 6, the gravity offense is much more higher than that. That is to there. So we in some cases, especially in the child marriage matters also, they added the POCSO matters. Obviously POCSO ethics also, but still there are some. So I raised the issue specially. Let us see, there may be some development. Anyway, we're listing it on Tuesday.
Tuesday again they may come that notice at best.
Let us see if he again comes in that manner or not.
My lord,
Cannot see it.
may I say one thing, lordship? Let the lordship amicus curiae may be appointed. Matter may be
No, we do not know about the status of the this one, the notice, whether it is been served, not yet, not paid. If it isn't served, immediately will appoint and they itself may hear the matter.
Notice was issued on 2310, more than 1
That
month.
I don't know. Now he is saying that it's not yet 2510.
25.
Obviously, about
We
1
have
month.
More, not about more than 1 month.
More than 1 month, obviously.
Once, my lord, it happened, my lord, in one of the case, my lord. The person, my lord, he has served the notice, my lord, but ultimately, my lord, second day he got transferred. Thereafter, no, report was not sent. Thereafter, I again has to.
There may be some
There must be
issues indeed.
That is what.
Okay, well, listing it on Tuesday. Let's assume that
Positively they may
Now we are trying our best, my lord.
list go to Bokare, and the additional Maybe Mr. Goswami is also hereby directed to take instructions in regards to the service of notice on respond number 2. Tuesday, this school Tuesday is 3rd of December. Realistic.
For admission, item 54, except 2.
Demand for.
May it please your lordship.
Yes. Yes.
This question petition has been preferred by the petitioner in pursuance to the special POCSO case number 50 of 2024 that is currently pending before the learned special judge POCSO POCSO. So basically the entire allegations of the matter is that the victim happened to be a relative of the accused and the informant happens to be also a relative of the accused. Now what has happened is that on the day of the incident, this victim, she was in her house and this accused, he actually had gone to attend with his family a marriage ceremony. Then while going, he came back because of the fact that he had to fetch a milk packet which was delivered to his place. And when he came back, he didn't have the key in his house. So he went to the nearest neighbor and he delivered that packet and told her, the neighbor, to hit the milk. While coming back, this victim girl saw him and that was it. Now what has happened is that as per the allegations, the victim girl has said that this person has visited her place on that day at around 11 a.m. while there was nobody in her house. She had stated in the 161 statement. Then in the 164 statement, she has stated that her mother was there inside the bathroom. Then this what has happened is that this mother herself also in her 161 statement, she had stated that she was in the bathroom. And then while she had come out of her bathroom, she saw that this person was there talking to her victim girl, minor girl, who is said to be aged about 12 years. The age is still not ascertained because there is no age report, whether she is 12 or more than 12 also from the documents. Anyways, now what has happened is that this girl, she has alleged that this informant who happens to be a known person to her had taken her to his house in absence of his relatives. And then he had done some sort of sexual act with her, forced her, and then she was led to come back and she came back. And then she narrated the incident to her mother. And the mother informed it to her husband, who was not there at that time. And then later on, the husband came back and after being narrated with the facts, he lodged an FIR on the very next day while discussing with his family what to do, how to go about. Now the entire matter is that this entire allegation was being like it uploaded because of the fact that there was some misunderstanding. This girl always used to know this person, this accused. She used to go and play. The accused being the brother-in-law of the informant. So they have a good relationship. Now on like few days back, they were having some issues of some civil nature, which is not yet mentioned in the petition, but they were having. And because of that, maybe of the fact that something was not in line with their thoughts with each other or both the families. So what has happened is that this girl may be made to feel a bit misrepresentation of the facts which she had narrated to her mother, because she used to visit to the place of the accused on familiar occasions on earlier times also. Now this entire gamut of the allegations has been charged by the police against this accused, and they have filed a charge sheet on 29/3/2024, and this was later on taken cognizance by the court on 5th of April 5/4/2024. Meanwhile, the accused was on bail. Now, Lordship kindly peruse to the FIR. The FIR is on page number 18. That is the FIR. So in the FIR, what I have just narrated, it is there. May I? Our neighbor Sri Nepal Das, son of late Dharani Das, visited my residence and persuaded my 12-year-old daughter Sweetie Das and taken her to his residence under the false pretext that her grandmother, who is also Nepal Das' mother-in-law, was searching for her. Thereafter, the accused person in his house touched her body inappropriately and kissed her as told by my daughter. And she narrated this to her mother, and she was put on bed and she was forced. She cried and then she left the house immediately. My daughter narrated the whole incident to my wife, who in turn informed me about the same. So this is what I have already submitted before your honorable court. Now going to the 161 statement, my lord, it is in page number 33. 34, my lord, annexure H. That is the 161 statement of the victim girl. First, we go to the 161 statement, then we go to the 164. In 161 statement, she says, on 11/3/2024, I was watching mobile phone.
Where is the page number?
34, annexure H.
No, 34 is 164.
Oh, my lord, my lord, that is, I'm absolutely sorry, 39. 39 is 161. Annexure I. My name is Sweetie Das. My house is in Sondonpur. I read in class 7 in Netaji Modern English School. I was watching mobile phone sitting on the bed around 11:30 a.m. the day before yesterday. My mother was not available at home at that time. This line to be marked. My father and Jethu, elder brother of the father, were in the shop at Pauli Market. Jethai, wife of elder brother of father, went to Guwahati. So here she says that my mother was not available at that time. That is 161. Now, if we go to 164, that is in page number 34, annexure H. My lord, kindly page to page number 34, annexure H. There she says that on oath, she says, on 11/3/2024, I was watching mobile phone sitting at home and my mother was in the bathroom. Nepal Das is my uncle, husband of mother's sister. Around 11:30 a.m. that day that is on 11/3/2024, and then she narrated the incident. So from the two contradictory statements of 161 from the victim, 161 and 164, it shows that maybe the victim might have been, she was a victim of some misunderstanding at that point of time. And an entire case has been lost due to some misrepresentation of the facts. And now what has happened is that, my lord, this informant's family, they are saying that they do not want to proceed. They do not want to proceed because of the fact that since they are family members, and as such, there are a number of judgments previously. It has been laid before this honorable court. In fact, this honorable court was pleased enough to pass an order where it has been taken into account that the main principles where this POCSO Act has been enacted. There are some principles, the objective of the POCSO. So out of those main principles, two principles are there that the interest of the victim child should be taken into account. Second, the victim child should not be made to go unnecessary hardships by facing the court proceedings. Now, what has happened is that now, since at that point of time when if the informant family, because the informant had lost the FI, so when he had been narrated with the facts, maybe he, out of exaggeration, he might have just thought that no, why this has been done to my daughter. But now when he has realized that the daughter might have said it in a way, because the from the statements of the daughter, two versions comes out, that the mother was not there, mother was there. So maybe, due to some of the fact that her age is also not that much, she's 12 years, but not yet has been ascertained. And though in 164, her voluntary statement has been taken, but there has been no test to understand whether she is understanding all the questions or not. So we'll not go into that fact, because 12 years is good enough to understand also, to know what is good and bad about what is happening around her. So our only contention is that now when the informant's family, if they do not want to proceed and they are thinking of not for settlement, they are now thinking of, in fact, tendering an unconditional apology also, that they have come out with these facts before the police, and now just because of the fact that there might be some sort of civil dispute also, or some sort of disputes personal in nature, which is very important, private and personal. So it is a well-known settled law, my lord, that when cases are private, personal in nature, though these are different, it is a heinous crime. Of course, POCSO is a heinous crime, but when it is private and personal, then it has to be taken into account. The balance, the convenience of balance has to be there. Also looking to the accused, because now this accused is not an unknown person. Yes, he's a known relative and he's a brother-in-law. So on that day, he himself, in his 161 statement, he has stated that I had gone to the marriage and then I had to come back, and then I fetched that milk packet to the neighbor. That same was corroborated by the neighbor also, because in the charge sheet, there are 5 witnesses. 3 of them are family members. One is the shopkeeper, that is the neighbor, and the other one is the IO. So there are no other specific documents or material evidences to directly suggest that this person was involved. In fact, the medical report also is very incomplete. May I peruse to the medical report? That is in page number 31. 31, my lord. That is the medical report, 31, Annexure G. So in the medical report, it just says that the case history, that is in the down portion of the first page of the report, 13. From the police, the girl was sexually assaulted by the neighbor on 11/3/24 at around 11:30 a.m. at the girl's house when no one is home. So now specifically he has not said at which place or where. Just no one is at home. He has stated and in the report, in the medical officer and the report there is nothing. In the opinion section also in page number 33, nothing has been mentioned. So this shows that maybe due to the fact that out of the exaggeration this case was lost, and also the sections that wrongful restraint, sexual assault, 376(3) is there. So for 3 to be there has to be a sexual act tending to intercourse. So that is not there. In fact, from the statement of the victim, she has stated that he has taken me, he has touched my breast and everything such like that. But there's nothing of that sort. Now maybe he might have some good relation with her as his own relative. And so many occasions, since their relatives, their house are adjacent to each other, they used to go. So if there was any case, then she could have also reported earlier also. If they were now on that day, because maybe there was some differences that was going on like few days back prior to the lodging of the FIR. So maybe I'm not saying that she might be tutored, but there might be some compulsion also. And on the fact that she was taken by the person in presence of the mother, kindly peruse to the mother's statement 161. That is Sobita Das. That is in page number 43, Annexure K. May I, your lordship? Annexure K, page number 43. That is the 161 of the mother. I am the mother of Sweetie Das. Sweetie and I were at home on the day of occurrence. After taking bath, I came out around 11 a.m. Right at that moment, the person Nepal Das by name came and told me that his mother-in-law had called Sweetie. So this means that this person has not taken the girl in absence of anybody. There was person, and that person was the mother herself. She knew that this person was taking her. And she also knew that there were no relatives in his place, because they are all relatives. Everybody knows that a marriage was happening. So in Indian culture, everybody knows where the marriage happens, and everybody is always aware of marriage. So right at that moment, person Nepal Das came by and told me that his mother-in-law had called Sweetie. That is grandmother of the victim. She calls Aita grandmother. So he said that grandmother is looking for you. No, it is very strange that even after knowing that nobody is there, this mother has asked her little daughter to go accompany him when nobody is there. In Indian culture, and also from the mother's point of view, mothers are very much, what you say, they always look after their daughters, and also adolescent daughters when she is now 12 years. So she will be more aware of where she should be going. Now, when she knows that there were no people there were no relatives in the house, she lets go her daughter to go along with his uncle, because she was confident enough on number of occasions that this person takes her sometimes and she plays with him, or even if in the presence of his relatives also. So this shows that they are totally aware of the things happening around them. It is not just one-off incident. Maybe a case now they want to just exaggerate it because there was some pressure of that civil dispute that was happening due to some sort of misunderstanding. So lordship, from the statement of the mother, from the statement of the victim, 164 as well as 161, and from the materials which have been seen in the medical report, as well as kindly go to the search sheet. Mind you, search sheet is very important. Page number 27, the search sheet starts, and the search portion is in page number 30. So what happens in page number 30 is there, in the last portion is the search. It's very interesting how the police actually, they files the search sheet also. Page number 30, my lord. The brief of the case. So here he says directly, the brief of the case is that so-and-so complaint Ajit Das lodged a written FIR at Kumarika outpost that on 11/3/21, namely Nepal Das raped his 12 years daughter Sweetie Das. Accordingly, a case was registered at Tamulpur PS and investigated. During investigation, recorded 161 CRPC of the complainant, victim, and witnesses recorded 164 statements of the victim. Drew a rough sketch map. During statement, victim stated that on the day of the accused, Nepal Das came to her home and asked her to go with him. She went to his house. That time, no other family members were present at his house. He kissed her forcefully on her face, lips, neck, chest, and touched her chest over the clothes and sexually assaulted her. Charge on the basis of the victim's statement, according to Section 375, subsection C of the IPC, accused Nepal Das, son of so was committed crime against the accused under the Section 341, 376, 354A, and then read with Section 8 of the POCSO. So this has been made out of the sole statement of the victim, and yes, though provisions are there in the POCSO Act that 160 under the statement of the victim, presumption can be drawn by this honorable court that yes, it has been committed. But there has to be some materials also, and there has to be some sort of evidences which gives a indication that yes, this has happened, and that this girl, if she has stated this, I have been repeatedly molested, or I have been repeatedly made to undergo sexual assault by this person on number 10, it would be a difference. On that day only, she would say, when there was no one in the family, the mother also was present at the time when she was about to leave her house to go to the accused place. So everybody knew what is happening. And now the father comes and she said that my daughter, she went, and then he taken her in the pretext that grandmother was calling, and then he did all these acts, and then she came back, and then she narrated this one, and then my wife narrated this to me, and that's why I have lost the affair. Now the father himself, the informant, is saying that no, maybe due to some sort of misunderstanding, I might have gone and I might have registered the case. Now, since the case is registered, now it is going to be taken for consideration of charge. Today was the day for consideration of charge, but since the matter has been listed here, the consideration of charge has been is fixed for another day. So this is the gamut of the case, my lord, and this is my humble submission. So I want to place few authorities where would like to draw the honorable court's attention regarding deciding on the matter regarding the inherent jurisdiction of this honorable court under section 482, so that there is no abuse of the due process of the court and there is end of justice, because of the fact that there is, I'm not saying it's settlement, but there is some sort of apology that is coming from the informant that they want to withdraw this case. And taking into account already this honorable court on earlier occasion in case of settlement also have passed orders stating that if there is a validation of that settlement, then this court can use its inherent power under section 482. So this is a fit case where at this moment, if honorable court wants to take it in a manner, it can use its discretion, it can use its power. And at the same time, I would also say that if court wants to go for further hearing, we can go for further hearing. In the meantime, stay should be granted so that this accused petitioner, he should not be also harassed, and neither should this victim family should be harassed, looking into and taking into consideration of the principles while enacting this act. Because there are 12 principles which governs the exact objective to bring this act into the picture. So out of those 12 principles, 2 principles have been already mentioned, that no hardship should be allowed to the victim child during the process, and also for interest of the child. Now she is a 12 years old child, she's in 7 years, class 7. Very soon she will be going to the senior secondary school. So her academic career is also there. If there is some sort of victimization, some traumatization, then it will not be good for her. If the family wants to say that no, that was a case which did not intended to be registered in this way, but they have registered the hero.
Okay.
That's what my humble submissions. Rest I want to leave with my learned senior colleagues on the other side.
Cut short, my lord. In fact, my lord, there was no criminal intent, my lord. That is what I am told, my lord. If your lordship kindly comes to page 26, I just take you to the second paragraph. Even the medical report, my lord, there is no external injury. Was located in the order of the, my lord, Special Judge Baksa, my lord. That order dated 18/2024.
Extra injury of whom?
My lord, of the, my lord. Sorry, it is on the accused person, my lord. Sorry, it should not have been victim. Otherwise, my lord, what I'll just place, my lord. The informant, my lord, he has sworn an affidavit that at that moment, it, my lord, they are family members, there is no doubt about it. The victim is the niece of the accused. In fact, my lord,
there was no criminal intent. In fact, at that point of time, my lord, in the heat of, my lord, at the heat of rage, my lord, the FIR was lost. Subsequently, my lord, this FIR has been, my lord, there is a affidavit from the informant side, my lord, stating that this was a completely case of mistake of facts and mistake of, my lord, of the situation at that point of time. So, my lord, we do not have any objection if the, my lord, case is passed. I am placing the original before this court, my lord. The thing, my lord, even if in the trial, my lord, the conviction will be bleak, my lord, because we will not be supporting the case. Even the accused has two daughters, my lord, they play together. The only thing, my lord, that there was otherwise no criminal intent. Because if there was a, my lord, commotion over there at that point of time, the FIR was lost. Lordship may keep the original affidavit on record, my lord, and in fact, my lord, I have no objection if the, my lord, matter is, my lord, settlement, my lord, on.
In some cases, my lord, compoundable but some cases are non-compoundable. But heinous offenses cannot be compounded. Yes, so there is one authority is there. My lord.
No, in the same case, my
Yes.
lord.
And then, my lord, in some cases, it was done, my lord. Seeing the, my lord, circumstances of the cases.
Even otherwise, 376 is not rated, my lord. Even there is no indication as such, only there.
Not registered also.
Please,
Where
no.
it is registered at 376.
It's 376 3.
So we'll find that at page 18, my lord.
Maybe the lawsuits.
341, 342, 354, 376.
Lordship, like to place few authorities that mentioned. If judgment, if Lordship would be pleased to go through.
You are Mr. W.R. Heard Mr. W.R. Methi, the learned counsel for the petitioner, and also heard Mr. MP Goswami, the learned additional PP, appearing on behalf of state respondent, and Mr. R. Day, the learned counsel appearing on behalf of the informants. Let's respond number 2. This is an application under section 482 CRPC for quashing of the Tamulpur PS, quashing of the charge sheet number 44 of 2024, filed in connection with Tamulpur PS case number 0053. Exactly the same. Case number is Tamulpur PS 0053.
That is arising out of the Tamulpur PS case number 53 of 2024. Now it is now pending before the learned special judge as case number special POCSO case number 50 of 2024.
Charge sheet is not charge sheet number so and so.
Charge sheet number 40.
Filed in connection with
Dated
Tamulpur PS case number 53 of 2024, dated 12/3/2024, and also paid for portion of the entire proceedings in connection with special case number case bracket of POCSO number 50 of 2024, pending before the court of learned special judge POCSO Baksa. POCSO Baksa. Copy was called for here. Scan copy of the case record was called. Received and a scan copy of the case record received, produced the same on both sides. He is in custody.
No,
No bail.
Yes. Bail was granted by this honorable court on 24/4/2024.
Charge has already been framed or not yet?
No, not yet.
Not yet.
Not.
Just fixed today, Miller, for consideration of charge. Bail order will also been found at page 55.
Annexer O.
So now it is full box. It is submitted by Mr. Methi, the learned counsel for the petition, that the present accused petitioner is innocent and he has not committed any such offense as alleged in the FIR, as alleged against him. He is a known known member of the known person of the victim, and earlier she used to come to the house of the accused in earlier occasion also, and on the day of incident also, as revealed from the statement of the mother of the victim, recorded under section 161 CRPC, that she allowed her daughter to go with the accused petitioner to their house when there was no one present in the house. But I think she went with the accused to his house.
Yes.
And then now otherwise she is saying that she was alone in the house.
Yes, that is right. She is contradicting in her own statement. In 164, she says that 164, she says that she is her mother. In 164, she says that her mother was in the bathroom. In 160,
But the incident happened in her own house.
no, not in her house. It happened in this one accused place.
And
Adjacent house. But
her mother must stays in the same house.
Yes, they were very like close house, and mother was in the house when she was taken by this person. Mother was there. She herself, she stated in 161. If Lordship goes to 161, she says that he had come, and then he had come to take her because grandmother was searching for her, and that is why she was there. She came out and she saw that.
Now, why she is saying that she was there and seeing the mobile in the.
She was in her house when this person came, my lord. This accused came. Accused came to the victim's place.
Then why in 161 there that she went to the house of the accused?
Yes, that is why she is contradicting in her own statement.
No, mother's.
Oh, mother is saying that she was in her house. This victim's mother was there in her house, and this victim was also there at that time when this person came. So it was in the knowledge of the mother when the victim went.
That's what I am. 15 went with the accused.
Yes.
Whose house? The accused house.
Accused.
The incident had taken in which place?
At accused house.
Accused house.
Yes.
And then why she is saying that her mother was not available?
Yes, that is the reason, my lord, that her statements are a bit contradictory. This was the reason why I pointed out before this honorable court regarding that she is deviating from her statements. In 164, she says that, and in 161, she says that mother was at home, and then 164, she says that mother was not there. So since there is some deviation, so the fact is that the deviation is there. Why? Because maybe of the fact that since this has happened, and she wanted to make her feel, her mother, that she's saying the correct one. Now what has happened is that maybe mother might have stated to the father in a different way. There's all possibilities, my lord, because father was not there, informant was the father. So father came, and when hearing the narration of the mother, he went and he lost the FI. So now, since the family, they think that now maybe there was some misunderstanding that was happening in the entire conversation of the victim with her mother, and then mother with the husband, who happens to be the father of the victim, because the father had gone to lodge the informant Ajit Das. He had gone. So if going through the statement of Ajit Das, he says that he was not there at that time. He was in his shop. Then he got a call from mother that such an incident has happened. So he came down, and then he had spoken at length maybe with his wife, that is the mother of the victim. And then after that, since there was some sort of misunderstanding already happening prior to the incident, there was some sort of civil dispute. Who knows, my lord? There is an angle, but the nature of the offense is, in this particular case, is very private and personal, because they are known people. And at the same time, the facts revealed from the medical report, there is nothing there, because medical was done on 13th. The 13th, nothing was there, no opinion was there. In fact, the entire case was registered by police just because of the fact that the informant had gone there to lodge it, and they had not gone through all the materials in the way, because of the fact that the age also needs to be ascertained. He should have seized the copy of the age, and it should have been produced in the charge sheet also. There is nothing in the charge sheet regarding the age also. So, and only just the statements of the witnesses, who are all interested witnesses if we go by law. We got the family members, and then there is one independent witness. That independent witness also states that yes, the accused had come to my shop to deliver that milk packet and asked me to hit that milk, that milk on his behalf because there was nobody. If he had gone to his house, if he was there, then definitely he could have done that milk. He could have heated that milk in his own house only. Then why he had? Because he had gone to the shopkeeper's place, that neighbor's place. And then what would be his motive? Then to again come back to his place, then where to go to the victim's place. So there happens to be a bit of
মাথায় কাম করা নাই একটু ডিসপোজ দেখাই দিন কি করবেন এরকম ডিসিশন রিডিং পিসা মানডে উইলে দিলেন হবে ওকে আর পাস অর্ডার
oblige my lord.
আপনি অলপ দেৰি থাকিলে ডিটেকশন টু দিব আপনি যাব নেকি কৰবাত আপনি গৈ হয়
My lord.
14.
Then appears on call for the petition list accordingly after 2 weeks.
16.
Make these elections. Here we have come in criminal revision against the impugn order. Judgment and order passed by the learned sessions judge in criminal appeal. Now matter actually pertains to order passed by the learned magistrate in a DV proceeding, domestic violence proceeding, where interim maintenance was granted. Against that, the second party has been preferred an appeal. Now, in the appeal, my lord, the interim maintenance that was awarded by the learned magistrate, that has eventually been upheld. Initially, there was a stay of that award of interim maintenance passed by the learned magistrate. And there was a reduction in the amount that was awarded by the learned magistrate, and during the pendency of the appeal, that reduced amount was being paid. But eventually the appeal has been decided against me, for which I am before this honorable court in revision petition, only on a very limited premise, my lord. If I take your lordship to the impugned judgment that is filled out here, if your lordship kindly takes up page number 40, it starts from page 48. And I'll take your lordship, my lord, from the operative part, which starts from page 50, which basically incorporates the entire crux of the matter. May I take your lordship to paragraph number 8 at page 50, my lord? My lord has got paragraph 8 at page 50. May I read this, my lord? In the proceeding of the Miss DV case, the respondent aggrieved had filed evidence of 2 witnesses, including herself. After hearing both sides on the point of interim maintenance and perusing the records, the learned court below has passed the impugn order dated 19/1/2021, directing the appellant respondent in the Miss DV case to pay rupees 4,500 in total per month to the respondent aggrieved. The respondent side was also directed to submit the affidavit on the assets and liabilities on 4/2/2022 and to cross-examine the PW. This appeal was filed challenging the order dated 19/1/2021, mainly on the ground that the order was passed without delving into the actual expenditure and income of the appellant, and thereby learned court will awarded an exaggerated amount as interim maintenance. From the above background, it appears that the only point is to be decided in this appeal is to whether the interim maintenance as awarded is inflated in comparison to the income and expenditure of the appellant, and whether the same amount is indispensable with regard to the maintenance of the aggrieved and her daughter in course of leading their daily lives. From the evidence of the respondent, who being an aggrieved submitted her evidence on affidavit in the said Miss DB case as PW, it has come to light that appellant is a renowned big businessman having business of wholesale medicine in the name of so-and-so at so-and-so, having more than 10 employees serving under him, and the appellant earns at least rupees 2 lakhs to 3 lakhs per month. She also deposed that her daughter has been reading in so-and-so at KG2 at so-and-so. She has also exhibited documents with regard to the business of his husband appellant, and in relation to the education of her child, her evidence was fully supported and corroborated by her mother, so-and-so, who has submitted her evidence in the case on affidavit as PW2. The next date of the case was fixed for cross-examination of PW1 and PW2. Until and unless the fact stated by the victim as PW1 in her evidence on affidavit is rebutted by way of cross-examination by the defense, the same cannot be discarded. From the assets and liabilities submitted by PW1 on affidavit, it has come to light that she is unemployed and totally dependent. The monthly income of the appellant is not clearly mentioned on the affidavit submitted by the appellant in his assets and liabilities. In view of the materials and evidence available on record, and considering the skyrocketing prices of the essential commodities for leading lives, and also the stage of the proceeding, I am of the considered view that the learned court below has rightly passed the impugn order awarding an interim maintenance of rupees 4,500 in total per month for maintenance of the aggrieved person and her daughter, including the education expenses of the child. It is not out of place here to mention that this appeal was admitted by my learned predecessor in office on 17/2/2021. But from the impugn order itself, it reveals that it is an interim order, and as such, filing of appeal against this order is not sustainable in law. At best, the appellant can file revision in this regard. In the result, with the above decisions, the appeal is dismissed on contest, and the impugn order dated 19/1/2021 passed by the learned court below in Miss DB case 16 of 2019 is hereby affirmed. The stay order, including the condition incorporated in it, passed by this court on 17/2/2021 is hereby vacated. The appellant is directed to pay a sum of rupees 4,500 in total per month to the respondent aggrieved in Miss DB case as per direction made in the impugned order dated 19/1/2021. Now, my lord, in a very limited sphere, my lord, we have assailed this judgment on the ground that the finding that has been arrived at and the observation that has been made in the impugned judgment, it says that until the witness is cross-examined, the evidence led by the witness is not rebutted. And on the basis of the evidence only from the chief, that is the examination in chief, the learned court came to the learned courts below came to the satisfaction that whatever is being stated by the party is a truth. Now, herein lies, my lord, my ground for challenge, where in my humble contention, it is just the other way around, that the evidence without cross-examination cannot be an evidence in toto. For an evidence to be impeachable, for unimpeachable, that has to be put to the test of cross-examination, which has not been done in the instant case. Here is a case where only the examination chief was submitted, and in which the lady had contended that her expenditures are of this nature. And she has also contended that the husband's income is this. That has to stand the test of cross-examination so as to be an unrebuttable evidence. Without there being any cross-examination, this evidence cannot form the basis of a satisfaction of any court to arrive at a conclusion that this is the income, and this is the income of the husband, and this is the expenditure of the wife. So only on this limited premise we have come before this honorable court that this judgment of the learned session judge passed in the appeal suffers from legal infirmity, and for which my humble prayer is that this judgment is liable to be set aside, and it has to be remanded back to the concerned court where the DV matter is pending, in the light of evidence, in the light of cross-examination which is yet to take place. Let there be a satisfaction arrived at by the learned court below that this is the actual income and this is the actual liability, this is the actual expenditure that the wife incurs and for which she is entitled to this interim maintenance. And thereafter, let an order be passed under the provisions of the DV Act. And insofar as the other observations made by the learned appellate court regarding the non-maintainability of the appeal, here also, my lord, I have raised the ground that this is also a misconception of the legal provision where Section 29 of the DV Act itself provides for provision of appeal against any order starting from Section 19 to Section 23 of the Act itself, which are all in the nature of interim orders. So there is no bar for filing an appeal under Section 29 of the DV Act against an interim order, and there is no question of filing a revision against that order. So that also is a misconception in our humble contention that was observed by the learned. Nonetheless, my lord, we are mainly on that aspect that the learned court below, the learned appellate court arrived at a finding or came to, made an observation that evidence, unless cross-examined, is unrebutted. But in our humble contention, it is just the other way around. That unless and until the evidence stands the test of cross-examination, it cannot be considered to be an evidence in toto. So unless and until there is a cross-examination on the evidence on the chief that has been submitted, this cannot be said to be an acceptable evidence, and on the basis of which this judgment has been passed. So this is basically my case, my lord. Otherwise, my lord, insofar as the figure is concerned, that of course, of the record, I have to say that in the present scenario, this is a very meager amount, and of course, but at the same time, my lord, at least there has to be following of a proper procedure of law to come to a conclusion. It can be even more than that also, but for that, at least a legal procedure has to be followed. Without following the legal procedure, the satisfaction arrived at by the learned courts below, in my humble contention, that is something that is not tenable in law, and for which it can go back and thereafter let there be cross-examination, let thereafter there be satisfaction arrived at by the learned court as to what is the exact entitlement of the wife, what is the liability of the husband to be paid. And my lord, one more aspect, since there has not been any stay of the direction to pay the interim maintenance after the dismissal of the appeal, we are constantly going on paying the my lord, I have been told by my learned friend that there is some shortfall in so far as payment is concerned. That of course I can always instruct my client to take care of. But nonetheless, he has been paying it since the time the judgment was passed, and there even before that also he was paying the interim amount that was awarded. Obligement.
Here in this matter, my lord, so I filed a DV case, my lord, and a learned trial court, my lord, in the very first case, it is on 19/1/2021, the interim measure, my lord, though awarded for 4,500 to me as well as my daughter, as well as my daughter's educational expenses, including 4,500, my lord, 2,000 to me, 1,500 for education, and 1,000 for my daughter's maintenance, my lord. Then, my lord, the present petitioner, before challenging that interim order, my lord, before the appeal, lordship, can I have a look the appeal at page 41? Challenging this award of 4,500, my lord. I read only, my lord, page 44, 3 paragraphs. He has challenged only three grounds. Agreed by the debt interim award of 4,500 to him, my lord. Page 44, 9, my lord, 9, 10, and 11. 9, Further, the appellant offered 2,000 only per month to pay as interim maintenance as the present situation of his business income, which has neither been accepted nor any reason shown for his non-acceptance by the learned court below number 10, my lord. Further, the learned magistrate was wrong to hold that a child of nursery required a 1,500 per month as tuition fees and education expenses. It is his father's contention, my lord. Number 11. Further, the learned magistrate ought to have granted 2,000 per month as interim maintenance to the respondent as the child considering present economical strengths of the appellant. He's basically this trigger. So he's taken that he's very much aggrieved that instead of 4,500 to me as well as to my daughter, it ought to have been the 2,000. Being aggrieved, my lord, he's preferred this appeal. Then, my lord, the appellate court, the learned my friend has just read. I'd like to draw your lordship kind attention, my lord. The paragraph 10 again, my lord, at page 51. Against the concurrent both the court's findings, the instant revision petition preferred, my lord. The proper evidence of respondent who being an aggrieved submitted her evidence on affidavit in the said miscase DB case number so and so. The PW1, it has come to light. The appellant is a renowned big businessman having business wholesale medicines in name of the so and so, having more than so and so rupees, and appellant earned at rupees 2 lakh to 3 lakhs per month. Okay, my lord. She also deposed that her daughter has been reading in Netaji Memorial Scale KG2 so and so. She has also exhibited documents with regard to the business of her husband and the relation of the education of side. Her evidence was fully supported and corroborated by her mother, Simply Rani Pal. My lord, I'm just pausing, my lord, here. Her evidence full, that means, my lord, that stage is, my lord, is a interim stage, my lord. There only that part, only evidence in chief is there, my lord. Cross not yet started that period. So the what about the evidence available on record that period? Therefore, that appellate court recorded this. Her evidence was supported, fully supported and corroborated by her mother, Silpi Rani Pal, who has submitted her evidence in the case on affidavit as PW2. The next date, my lord, kindly mark it, my lord. The next date of the case was fixed for cross-examination of PW1 and 2. That means, my lord, cross not yet that started, my lord. Cross, it is open for the defense to make cross to the PW1 and PW2, my lord. It is not nowhere. It is the learned court stop that no further you cannot do any cross to that. It is open for him. There's a cross. It's still there, my lord. Until and unless the facts stated by the victim PW1 in her evidence on affidavit rebutted by the way of cross-examination by defense, the same cannot be discussed. How the present petitioners agree on this point? That means, my lord, what learned appellate court is here, my lord, since there is only chief examiner chief is done, my lord, and cross yet to be done. So, my lord, until and unless he has ample opportunity in the cross, my lord, in the defense, he could debate whatever evidence, evidence, it is open for them. Whether only for this ground, he preferred this instant revision petition. Next, my lord. Until and unless it is, sorry, my lord, rebutted by this cross-exam by defense as same. From the asset of liability submitted PW1 on affidavit, it has come to light that she is an unemployed totally. I am not there, my lord. Next, my lord, my learned friend has just read one paragraph 12. It is not out of place here to mention that this appeal was admitted by my learned predecessors in office number so and so, but from the impleal order itself, it reveals that it is an interim order, and as filing of appeal against such order is thus not sustainable. At best, the appellant can file revision in this regard, my lord. This is just simple an observation, man. Not this is by relying this statement, it is not dismissed, my lord. This is only one observation, but the appellate court has dismissed their appeal on the findings of the learned trial court, my lord's observation. Not on this point, my lord. Paragraph 13. In the result with the above decision, the appeal is dismissed on contest, my lord. An impugn order dated 19/1/2021 so and so is hereby affirmed. Finally, paragraph 15, my lord. The learned trial court below shall fix up and next date sending notice to both the parties within 2 weeks of receipt of the copy and this judgment. Then, my lord, challenging the learned first appellate court has directed the learned trial court to restart the case from the cross part, my lord. But thereafter, my petitioner has approached before the court, though there is no stay order is obtained here, my lord, but as per my information I received, my lord, there's no progress is going on there, just because of pendency of the matter, my lord. Just because of 4,000, 2,000 to me and 2,500 to my daughter, he challenged before the appellate court, and he challenged that the 2,000 ought to have been given, awarded only 2,000, not 4,000. It is his sentiment. He appellate court, he has come, then he high court come, he has enough money, but he is not ready to pay that 4,000. Now he raised a legal point that we can the London appellate court is recorded just because of the until and unless rebutted by this evidence, this evidence will be accepted. This is the evidence part, at the examination sheet part, that observation is made, not cross yet to be initiated, my lord. So my humble sum at this stage, I am very unfortunate to say, my lord, just because of this crown challenging the revision here, this is nothing just to delay the process. Lordship may dismiss this petition, and whatever, even more over, my lord. Most importantly, the prayer, kindly have a look on prayer, my lord. Two impugn orders are there. One 19/1/2021. The first impugn, it is still on force, my lord. Kindly, my lord, his prayer, my lord. Page 14. It is under challenge only 18/4/22. Whereas the main impugn order is a 19/1/2021. Yes, it is not challenged there, my lord.
No, he is challenging.
In the appellate court finding, my lord, but that while, my lord, that impugn order 18/4/2020 was affirmed itself, this initial order is also dear, my lord, that is 19/1/2021, my lord. Where is the first interim awarded, my lord? So by at this stage, my only humble submission, my
Just
lord.
see, pending disposition so and so, the state impugn order dated, acha, 18/4.
Yes, but 19/1/20 is not there.
No, whereby the 19/1 was confirmed or affirmed.
Confirmed. The appellate court.
No, that is there only.
Lordship, instead of going to that, my lord, this is my just lordship, to lordship knowledge, I have shown this prayer. My humble submission, my lord, such kind of on interim measure, trial court is awarded 4,500 to me and my daughter, my lord, are interfering such kind of order, since it is open for them to cross, and instead of interfering this order, my humble submission, let the proceeding be initiated, and matter maybe he is also get the ample opportunity to cross to all the PWs, my lord. So instead of interfering matter may be closed, my lord, and trial court is there, my lord. Lordship and give direction to trial court initiate from the evidence cross. So nothing to be interfered of this order passed by the appellate court. It's very much very open for him, my lord, to cross.
My lord, just to respond to what my learned friend has said. My lord, of course, he has on record gone on to hit a sentimental issue that a father is running from here pillar to post for litigations, incurring expenses, but he cannot pay the money to the wife and to his own daughter. My lord, off the record, my lord, I have submitted a while back that off the record, my lord, even I have sympathies for the wife and the daughter. But on record, we have to go by law. Now, here is an observation by the learned appellate court where it says that after appreciating the evidence of PW1, which is corroborated by the evidence of PW2, since the witnesses are yet to be cross-examined, so their evidences cannot be rebutted. But the position of fact is the other way around. Your lordship kindly takes the provision. This is something that is a codified provision, section 138 of the Indian Evidence Act, which was as applicable at that point of time, which says that witnesses shall be first examined in chief, then if the adverse party so desires, cross-examined, and then if the party calling so desires, be re-examined. So it is a settled provision of law that an examination in chief by a witness, until and unless put to the rigors of cross-examination, cannot be. If there is no cross-examination after providing opportunity, then the evidence holds, then the evidence stands valid. But unless and until the cross-examination part is over, how can only the examination in chief be relied upon to form a satisfaction that this is the income? They have contended that I am a big businessman earning 2 lakhs to 3 lakhs per month, having 20 employees. Can these only on the basis of the examination in chief be accepted as a gospel truth, madam? Until and unless I am given an opportunity to cross-examine them on their contention, which thereafter may turn out not to be a correct position of fact. So until that opportunity is given to me, and until and unless that procedure is completed, opportunity I still have. It is not that that opportunity, as rightly pointed out my learned friend, that has not been closed. That opportunity is still there. That is why I am saying it has to go
So
back.
at the time of filing your written statement,
My
have you annexed your assets and liabilities?
Assets and liabilities were
You have
annexed.
annexed?
We had annexed.
Yes.
And in that also.
Now see, this is the interim order only.
Yes.
So prima facie cases there that can be, obviously it can be challenged. I would say it, but it's not that without cross-examining the PWs, either if it is cross-examination is already over, suppose, then the final order can be passed also.
True, my lord.
And after final order, suppose there may not be 4.5 thousand, it may
less,
be
it may be
reduced
more.
or it may be increased. That is up to the
Yes.
court. So that is the question.
My humble contention, my lord, here the ground on the basis on which the appeal has been rejected is the fact that on the basis of evidence appreciated, the contention of the PW1 and PW2 has been taken to be a truth, a gospel truth. Now, how can that be unless and until they are cross-examined over it? If that is the basis, only basis on which this judgment has been passed, in that case, there is a legal error, my lord. That is my duty to point out to this honorable court that there is a legal error. Now, whether that legal error is fatal in the context of the subsequent course of proceedings, that of course, that of course will depend as to what kind of evidence is led and what kind of cross-examination takes place. But as of now, my only respectful submission is that the basis on which my appeal has been rejected is taking the evidence of PW1 and PW2 into consideration and holding those to be unrebuttable since cross-examination has not taken place. So at least there could have been, my lord, an endeavor to go for cross-examination, or even in that case, after cross-examination, it was found that the evidence led is correct. There would not have been any embargo in passing this judgment. But here it has been passed only taking into consideration the evidence in chief, not the cross-examination part. This is my only case, my lord. Only on the legal infirmity.
Yeah, obviously, the observation that it could not be rebutted or it's not rebutted, that I am doing also that thing that should not be. But the question is that this is the only prima facie satisfaction of the learned trial court below, not the appellate court.
My lord.
So that is there only.
But at the same time, my lord, the learned appellate court in the interregnum had stayed the award of the learned magistrate by directing us to pay a reduced amount, which we kept on paying. So
earlier, what was the amount?
4,500.
Now you're paying?
Now also 4,500. In between,
What is the reduction then?
There was a reduction from 4,500 to 2,500. I have annexed that order. That was an interim order during the pendency of the appeal. The learned appellate court.
Earlier.
Thereafter, when the appeal was finally decided, the order of the magistrate has been. So my prayer as of now, perhaps would be, my lord, if in any case, my lord, your lordship is pleased to remand this matter back for appreciation of evidence by way of cross-examination, opportunity for cross-examination. At least this or impugn order should be set aside. And in the interregnum, if your lordship directs me to go on paying the amount which was directed by the learned appellate court, that amount, my lord, the petitioner can go on paying until and unless there is an adjudication by appreciation of evidence and cross-examination as regards the exact entitlement of the.
No. At the time of filing of that said appeal, there was a reduction. But after final order, again it is 4,500. Now you're paying 4,500 or 4,500.
4,500. And that is why we are aggrieved that this 4,500 we are paying because of an observation which is not legally tenable. That it has been accepted that PW1 and PW2, their evidence is absolutely a gospel truth, only on the basis of their evidence without cross-examination. That is my only contention, my lord. And as I am, my lord, of the record, I am again saying that I am, insofar as the amount is concerned, it is rather embarrassing for me to be arguing on this very amount. But I am only on the legal infirmity, my lord. If your lordship, my lord, if this honorable court finds a legal infirmity, obviously, notwithstanding, my lord, the pragmatic scenario, will obviously be pleased to take note of the fact that there is a legal infirmity and that is obviously required to be corrected.
My lord, I concluding my submission, my lord. No, my lord, my learned friend, on this single point is hurting only, my lord. And my only submission, my lord, at which stage he has challenged before the appellate court, my lord. That means examination chief are there, my lord, already. At this stage, he approached before the appellate court. So whatever the material available before the court, appellate court has to pass order on the whatever evidence is there. So my humble submission, my lord, instead of interfering this matter, my lord, so under trial court where main the case is pending, let initiate the process and he will get the opportunity to cross me order, and accordingly, my lord, whatever.
He is also on that the matter may be remanded and started the cross
But already the appellate court is remanded already. Appellate court, original court, my lord. It is also matter is there, my lord. No stay order is here till date, my lord, in this matter. 2023 is 5, now is to the end of the going on, my lord. So already where matter is pending, my lord. No stay is there, my lord. That's because of, my lord, this matter is pending. If no stay order, no progress is going on there, my lord. So, my lord, at this, my lord, instead of interfering this order, my lord, if the lordship may observe the direction below learned as expeditiously, my lord, to initiate the process, and petitioner will get a chance for a cross-examination of the PWs, my lord, and accordingly the DV court will decide on the merit, my lord. So instead of interfering this finding, already appellate court has remanded back the matter to trial court, my lord.
My lord, it appears we both are on the same page, only the difference being that I pray for setting aside of the impugn order, my learned friend wants it to keep it intact. But otherwise, we are
The
both.
question is, if it is suppose the order is set aside, then the order passed by the learned trial court below or the appellate court regarding the direction of payment of 4.5 thousand may not be there. That is the one issue.
Yes.
Suppose if it is, if it is, I mean, the set aside.
If it is not set aside, my lord, then trial court, as normal procedure, my lord, it will, the trial court will start, and it is open for them. Already appellate court is recorded, my lord. It is open for them for cross-examining all the PWs, my lord. Even examine, if we get opportunity to get rebut all the evidence, my lord, then the amount awarded, my lord, you get lesser amount, maybe. Might be, my lord, to increase that amount, my lord. So in case my only humble submission in such matter, my lord, interference is not source, my lord. And so learned trial court being directed to expedite us to initiate the process.
No, say whether it is to be set aside. Now, one point is there, as is pointed out. That rebuttal of PW1 and 2, that observation cannot be there.
That is one situation I can review, my lord. That, my lord, at the examination of chief part also they are in the trial court, my lord.
No. Yes, obviously.
Against the examiner, whatever material they are examining chief are there, same record are available before the appellate court, my lord.
No. The observation made by the appellate court that there is no rebuttal evidence of the PW1 and 2. Is there any? Read this sentence.
Yes. The next date of the case was fixed for cross-examination of PW1 and 2, my lord. Until and unless the facts stated by the victim of the PW1 in her evidence on affidavit, my lord, that means whatever she has stated in her evidence in chief, until and unless the facts stated by the victim as in evidence on affidavit, rebutted by way of cross-examination, my lord, cross-examination not yet started. How is affected, my lord, this point, my lord? Where is this bar that you will not make any cross-examination? This is open for them, my lord.
Bar is not there.
Yeah. So my humble
Observation,
submission,
regarding the observation.
my lord, in her evidence on affidavit, whatever evidence were available on record at that moment, my lord, so the trial appellate court didn't fit. So it is open for them to cross-examining the PW1, my lord.
Obviously, now no one has barred them to cross-examine. They will cross-examine. The observation part only is there. That is, he is hammering on.
Suppose, my lord, in chief someone has said something, but at the time of cross-examination, and this evidence is available on records, my lord, it is open for the defense. Yes, these are stepping this incorrect. Then he get accordingly, my lord, he may defense, he take defense plea on that plane. Nothing, my lord, nothing to be interfered on this point only, my lord. Nothing cross the redaction of the appellate court while watching this order, my lord. My humble submission at this means on the technical ground, this point only, my lord. Instead of interfering, my lord, let the appellate court decide at this earliest, my lord. He will get chance to cross-examining me as well as the whatever the PWs are available there, my lord. Instead of interfering, my lord.
Legal informity, not technicality, legal informity.
But sometimes such matter, such kind of matter, my lord, the lordship may can overlook on this one, my lord. It is not nothing will have worked, and whatever suppose had it been observed by the learned epilogue, you will not get any chance to make part of cross examination. Then if the lordship is very got opportunity to interfere on this point, my lord. Yes, it is open for him to revert all the examination made by the PWs below. So my submission, my lord, since both the courts below had awarded this amount, but instead of interfering this judgment below, lordship give direction to the trial court below to initiate the process. Since 2020, there is no stay around this point, my lord. Oblige, my lord.
Oblige, my lord. My lord is reserving the judgment. Oblige.
Time is not there.
Yes, my lord. Oblige.
How taking it? Yes. One meter, maybe problem. Only 71 meter.
Item 17.
Please, your lordship. Lordship has had a very long day. This is again another DV case, my lord, where multiple issues of law are involved. So if
My lord,
otherwise it is
my lord,
agreeable to my
I
friend.
am objection, my lord, because their petition is not maintainable, my lord.
Submit on mail.
Let me. That is why taking earlier also occasion also they have taken time, my lord.
Nobody is taking time. Let me submit. I was going to submit. Why is the respondents are submitting before I?
Revision is not maintainable, my lord. Domestic violence, my lords, a final order. They have to approach before the session court without going to the, they have agitated this forum, my lord.
Is this
Special provision, my lord, 29.
Let him submit.
Not maintainable revision petition, my lord. That is why taking, my lord.
Yes, take up the matter.
Oh.
Since he has raised the issue of maintainability on the ground that revision, this is a 482 application, not a revision petition, whether 482 application is maintainable in view of the alternate.
This one is criminal petition.
Criminal petition under 482 CRPC. Now, whether 482 application is maintainable in view of the alternate remedy which is available in terms of section 29 of the DVA. Now, my lord, first of all, my lord, if your lordship takes up section 482, I'm also placing all the authorities as to why and how it is maintainable. And we'll also come to the perjury which has been committed by their side. That is another issue. First, my lord, section 482 CRPC.
No problem.
My lord. My lord, 482 starts with a non-obstante clause, my lord. That nothing in this court shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this court or to prevent abuse of the process of any court or otherwise to secure the ends of justice. So, my lord, when it starts with a non-obstante clause, that nothing in the court. So, if there is any other provision, there is no provision, my lord, which can create any prohibition in the exercise of the inherent jurisdiction of this honorable court, my lord. 482 on that point is very clear. So, my lord, I'm relying on a few judgments, my lord. First, your lordship will take up Dhariwal Tobacco Private Products Limited versus State of Maharashtra, my lord. 2009 2 SCC 370. Starts with paragraph number 1, my lord. The first issue, my lord, which was raised in this case is
So before coming to the any of this, you was just reminding only this arguing on point of maintainability.
I would otherwise have argued on the point
Okay, then you
fact, my lord,
start.
since he has raised on maintainability, my lord.
Well, the issue which was before the Honorable Supreme Court was whether an application under section 482 of the CRPC can be dismissed only on the premise that an alternative remedy of filing a revision application under 397 of the code is available, is the question involved here. And so the question was, if there is an alternate remedy available, whether an 482 application can be dismissed just because an alternate remedy is available, my lord. Now, my lord will kindly come to paragraph 11. Paragraph 11. Lordship has paragraph 11. We may furthermore notice that in CBI versus Ravi Shankar Srivastava, this court, while opining that the High Court in exercise of its jurisdiction under section 482 of the code does not function either as a court of appeal or revision held, the exercise of power under section 482 of the code in a case of this nature is the exception and not the rule. The section does not confer any new powers on the High Court. It only saves the inherent power which the High Court possessed before the enactment of the code. It envisages three circumstances under which the inherent jurisdiction may be exercised, namely, to give effect to an order under the code, to prevent abuse of the process of court, and to otherwise secure the ends of justice. It is neither possible nor desirable to lay down any inflexible rule which would govern the exercise of inherent jurisdiction. No legislative enactment dealing with procedure can provide for all cases that may possibly arise. The courts, therefore, have inherent powers apart from express provisions of law, which are necessary for proper discharge of functions and duties imposed upon them by law. That is a doctrine which finds expression in the section which merely recognizes and preserves the inherent powers of the High Courts. All courts, whether civil or criminal, possess, in the absence of any express provision as inherent in their constitution, all such powers as are necessary to do the right and to undo a wrong in the course of administration of justice on the principle such and such. While exercising powers under the section, the court does not function as a court of appeal or revision. Inherent jurisdiction under the court, though wide, has to be exercised sparingly and carefully and with caution, and only when such exercise is justified by the text specifically laid down in the section itself. It is to be exercised ex debito justitiae to do real and substantial justice, for the administration of which alone the courts exist. Authority of the court exists for advancement of justice, and if any attempt is made to abuse that authority so as to produce injustice, the court has power to prevent abuse. It would be an abuse of the process of the court to allow any action which would result in injustice and prevent promotion of justice. In exercise of the powers, the court would be qualified to quash any proceeding if it finds the initiation, continuation of it amounts to abuse of the process of court, or quashing of these proceedings would otherwise serve the ends of justice. When no offense is disclosed in the complaint, the court may examine the question of fact. When a complaint is sought to be quashed, it is permissible to look into the materials to assess what the complainant has alleged and whether any offense is made out, or even if the allegations are accepted in toto. It is interesting to note that the Bombay High Court itself has taken a different view. In a decision rendered by the Aurangabad bench of the Bombay High Court, a single judge in such and such, where a similar question was raised, opined as under, it is difficult to curtail this remedy merely because there is a revisional remedy available. The alternate remedy is no bar to invoke power under section article 227. What is required is to see the facts and circumstances of the case while entertaining such a petition under article 227 of the Constitution and or under section 482 of the Criminal Procedure Code. The view therefore taken in both cases, VK Jain and Saket Gore, no way express total bar. If no case is made out by the petitioner or the party to invoke the inherent power as contemplated under 482 of the Criminal Procedure Code and or the discretionary or the supervisory power under 227 of the Constitution of India, they may approach to the revisional court against the order of issuance of process. Taking into consideration the facts and circumstances of these cases, the learned judge has observed that in VK Jain and Saket Gore that it would be appropriate for the parties to file revision application against the order of issuance of process. There is nothing mentioned and or even observed that there is a total bar to file petition under section 482 Criminal Procedure Code and or petition under 227 of the Constitution of India. Now, this was a two-judge decision, my lord. Subsequently, because of some conflicting decision, this matter was referred to a larger bench, my lord. Now, there is a three-judge decision, my lord. This is Prabhu Chawla versus State of Rajasthan, my lord. 2016, 16 SCC 30, my lord. Again, this issue was discussed as to whether the present availability of an alternate remedy is a ground to dismiss an application under section 482 CRPC, my lord. One in paragraphs 1, 2, and 5, my lord, lay down the foundation as to what has happened. And my lord will find the starts from para 6, my lord. Internal page 34.
In our considered view, any attempt to explain the law further as regards the issue relating to inherent power of the High Court under Section 482 is unwarranted. We would simply reiterate that Section 482 begins with a non-obstante clause to state such and such. A fortiori, there can be no total ban on the exercise of such wholesome jurisdiction where, in the words of Justice Krishna Iyer, abuse of the process of the court or others extraordinary situation excites the court's jurisdiction. The limitation is self-restraint, nothing more. We venture to add a further reason in support. Since Section 397 CRPC is attracted against all orders other than interlocutory, a contrary view would limit the availability of inherent powers under Section 482 CRPC to only petty interlocutory orders, a situation wholly unwarranted and undesirable. As a sequel, we are constrained to hold that the division bench, particularly in para 18 in Mohit, in respect of inherent power in Section 482 CRPC does not state the law correctly. We record our respectful disagreement. In our considered opinion, the learned judge of the High Court should have followed the law laid down by this court in Dhariwal. There was the earlier judgment and other earlier cases which were cited, but wrongly ignored them in preference to a judgment of that court in Sanjay Bhandari, passed by another learned single judge. As a result, both appeals. So this was my lord. This was the decision, my lord. Please as also. So the issue that even if there is an alternate remedy available, does not in any way curtail the inherent jurisdiction of this honorable court. Of course, the honorable court will consider whether this is a fit case to exercise Section 482 or not, my lord. And specifically on this issue, my lord, as to whether in a DV case, my lord, this can be examined or not. This is, my lord, Calcutta High Court, 2021, SLC Online, Calcutta 2602. Here also, my lord, the issue was the question that requires an answer in the instant revision is whether an order passed by learned magistrate in a proceeding under Section 12, read with Section 23 of the DV Act, on the point of maintainability of the said proceeding can be quashed under the provisions of Section 482 of the Code of Criminal Procedure. Now, my lord, will kindly come to para 47. Lordship has para 47. Similarly, there is no bar in invoking Section 482 in the cases under the PWDV Act. In Suresh Ahiwar and Priya Ahirwar, such and such wide order dated such and such, the Madhya Pradesh High Court quashed a proceeding under Section 482 of the Code, where aggrieved person implicated some persons or respondents in a proceeding under Section 12 of the Act, with whom she had no domestic relationship. Now, next, my lord, para 50. The next point for adjudication is as to whether an appeal under Section 29 shall lie against an order passed by a learned magistrate or metropolitan magistrate upon an application filed by the respondents challenging maintainability of the application under Section 12 of the Act. There is again divergent opinion of different high courts. It is, however, pertinent to note that difference of opinion arose on the question as to whether any order passed by the learned magistrate on an application under Section 12 of the said Act is appealable, or an order adjudicating the right to relief under Sections 18 to 22 and 23 is appealable. In such and such, the scope of appeal has been formulated as under. And then appeal will lie under Section 29 of the said Act against the final order passed by the magistrate under Section 12, subsection 1. Under subsection 2 of Section 23, the magistrate is empowered to grant an ex parte relief in terms of Section 18 to 22. And they give the list of all the offences where, my lord, an appeal lies. Now, para 52, my lord. The order on an application challenging maintainability of a proceeding under Section 12 of the said Act by the respondent or any of them is final in nature, because if the learned magistrate allows the application, it would mean dismissal of the application under Section 12 of the said Act by the aggrieved person. On the other hand, if such an application challenging maintainability is dismissed, the rights of the respondents are affected. Therefore, an order passed by a learned magistrate upon an application challenging maintainability of the proceeding under Section 12 of the said Act is, in my considered view, appealable under Section 12 of the Act. An aggrieved party may challenge the order of the Court of Appeal under Section 29 of the said Act in revision under Section 397 read with Section 41 of the Code. Now, this para is important. A respondent can challenge maintainability of a proceeding under Section 12 of the said Act without filing such application before the learned magistrate in the High Court by invoking his inherent jurisdiction under Section 482 of the Code. In other words, in order to invoke Section 482 of the Code, it is not required as a precondition that the respondent shall have to file an application challenging maintainability of the proceeding before a learned magistrate, and then appeal and finally an application under Section 482 of the Code. So, para 55, my lord, summarizes the law on this issue, my lord. So, if there is a case where the respondent is challenging the maintainability of the very DV Act proceeding, my lord, in that case, in terms of the Honorable Calcutta High Court, my lord, a petition under Section 482 is applicable. Now, in this case, my lord, this case, we have come before this honorable court under 482, challenging the entirety of the case on its maintainability. And my lord, I will demonstrate why, my lord. This is a case, my lord, where the petitioner and the respondent, my lord, in 2011, from 2011, they started to live separately. Now, in 2022, my lord, the aggrieved goes and files a divorce case against me. The divorce suit is decreed ex parte against me on 22/8/2022. My lord, will kindly note the date, 22/8/2022. The divorce suit is decreed ex parte against me. So on that day, the marriage stands dissolved. Now, this DV application, my lord, is filed on 1/9/2022, after dissolution of the marriage. Now, at the time when this divorce application, this DV application is filed on 1/9/2022, since it was the aggrieved who had filed the divorce suit, had perfect knowledge that the marriage had been dissolved. Yet when the aggrieved files this application, she does not mention that this marriage has been dissolved. Now, our Honorable High Court, Honorable, kindly help this gentleman. Again, my lord, deciding a 482 application in Bismita Soikia versus Pranjal Dotto, my lord, 2018 3 DLP 197, paras 8, 9, and 10, my lord. Yes, may I read para 8, my lord. In the case of such and such, the Punjab and Haryana High Court answered two questions which are relevant to the instant petition. Firstly, whether the wife can file a complaint under the DV Act when the relationship has come to an end with a decree of divorce. And secondly, whether the definition of aggrieved person also includes a divorced woman. While answering the two questions, the court looked into consideration of the statutory definitions of aggrieved person and domestic relationship and came to a conclusion that by virtue of use of the expression who is or has been instead of who was or had been by the legislature indicates the domestic relationship must be present and not of the past. This view is supported by the definition of domestic relationship occurring in section 2F of the DV Act. Therefore, existence of a domestic relationship on the date of filing an application under section 12 of the DV Act is a condition precedent. Similar view was taken by the High Court of Andhra Pradesh in the case of such and such, the High Court of Delhi in the case of such and such, wherein it has been held that the existence of jural relationship of the petitioner aggrieved person and the respondent is a condition precedent to filing of an application under section 12 of the DV Act, lest the application is not maintainable. In the case of Inderjit Singh Garewal, the apex court held that permitting the magistrate to proceed further with the complaint is not compatible and in consonance of the decree of divorce, which still subsists and thus amounts to abuse of the process of the court. In another case of Krishna Bhattacharjee, the apex court held that when there is severance of status between the aggrieved person and the respondent as husband and wife by a decree of divorce, the former ceases to be an aggrieved person so as to entitle her to reliefs under the DV Act. The apex court in the case of Dr. Buddhi Kota Subbarao opined that no litigant has a right to unlimited drought to get his affairs settled in the manner as he wishes. Every access to justice should not be misused as a license to file misconceived or frivolous petitions. On an anxious consideration of the rival contentions made by both the parties to the instant petition, this court is of the considered opinion that the marriage between the petitioner / alleged aggrieved person and the respondent number 1 stood dissolved by a decree of divorce. The domestic relationship automatically came to an end. Therefore, in the instant case, as long as before filing of the application under section 12 of the DV Act by the applicant petitioner on 18/11/2015 against the respondents, their marriage stood dissolved by a decree of divorce on 15/9/2014, thereby their domestic relationship got terminated, the application has become not maintainable in law. So, my lord, it is their DV application, my lord, which becomes not maintainable in light of the law which has been laid down by this honorable court in, my lord, Bismita Saikia. Also, my lord, in Inderjit Singh Garewal, this is again apex court judgment, my lord. This judgment also recognizes that DV application can be quashed. Para 2, my lord. May I read, my lord? This criminal appeal arises from a judgment and final order dated 9/8/2010 in Inderjit Singh Grewal versus State of Punjab, passed by the High Court of Punjab and Haryana at Chandigarh, by which the High Court had dismissed the application filed by the appellant under Section 482 of CRPC for quashing complaint number such and such, dated such and such, filed by the respondent number 2 under Section 12 of the DV Act. So here, my lord, they had filed a Section 12 DV Act application, my lord, under 482, which was dismissed. This order was challenged in the Supreme Court, so Honorable Supreme Court sets aside the Honorable High Court's order, and my lord passes the proceedings. Now, my lord will kindly come to para 31. Para 31. Your Worship. In D. Veluswamy versus D. Pachiamal, this court considered the expression domestic relationship under Section 2F of the 2005 Act, placing reliance on an earlier judgment in such and such, and held that relationship in the nature of marriage is akin to a common law marriage. However, the couple must hold themselves out to society as being akin to spouses in addition to fulfilling all the requisite conditions for a valid marriage. The judgments are distinguishable on facts as these cases relate to live-in relationship without marriage. In the instant case, the parties got married and the decree of the civil court for divorce still subsists. So this was also a case where there was a decree of divorce. More so, a suit to declare the said judgment and decree as a nullity is still pending considerations by the competent court. Submissions made by Shri Ranjit Kumar on the issue of limitation in view of the provisions of Section 468 CRPC that a complaint could be filed only within a period of 1 year from the date of the incident seem to be preponderous in view of the provisions of Sections 28 and 32 of the 2005 Act, read with Rule 15(6) of the PWDV rules, which make provisions of CRPC applicable and stand fortified by the judgments of this court in Japanese Sahu and Noida Entrepreneurs. In view of the above, we are of the considered view that permitting the magistrate to proceed further with the complaint under the provisions of the 2005 is not compatible and in consonance with the decree of divorce which still subsists, and thus the process amounts to abuse of the process of the court. Undoubtedly, for quashing a complaint, the court has to take its contents on its face value, and in case the same discloses an offense, the court generally does not interfere with the same. However, in the backdrop of the factual matrix of this case, permitting the court to proceed with the complaint would be a travesty of justice. Thus, the interest of justice warrants quashing of the same. So quashing is also allowed. This in a way also answers the issue of maintainability. Supreme Court also recognizes the fact that this is also a case where there was a divorce. Additionally, the Honorable Supreme Court also brings in the issue of limitation under 468 CRPC to this case. This was a case 2011 onwards, they have been living separately. She comes in 2022. See if she files a divorce suit. Divorce gets decreed. Now, after dissolution of the marriage, it was not during pendency when they filed the complaint, this Section 12 complaint. They filed it after the dissolution of the marriage. So on that ground itself, my lord, this petition is not maintainable. And one final issue, my lord, we could have raised all of these issues before the trial court. In this case, your lordship will appreciate one aspect, my lord. Page 39, my lord. 38 and 39, my lord. How the illegality is perpetuated, madam. 38 is the order whereby the learned JMFC Nogao decides to issue notice against the respondent. The learned magistrate does not prescribe the mode in which the notice is to be taken, but says it issue notice to the above named respondents, asking them to show cause as to why the relief claim by the aggrieved person shall not be granted to her. Now, 39, my lord. 22/11/22. Next day, my lord, the respondents are absent without steps. On perusal of the case record, it is seen that aggrieved on the last date had submitted the track consignment report, and perusal of the same shows that it was served on the respondents on 27/9/2022. Considered as such, the service on the respondents is deemed to be served. Now, my lord, when, if one goes by the analogy of Section 27 of the General Clauses Act, my lord, regarding service of notice by way of postal service, my lord, Section 27 only recognizes when either the Central Act or the regulation recognizes or directs the issuance of notice by postal. Section 27 is very clear, my lord. I could not bring the judgment, but there is also a judgment by this honorable court on this issue, expressly recognizing that unless and until the law recognizes that notice is to be served through registered post, or there's a specific direction of the court that notice is to be served by registered post, then in that case, Section 27 of the General Clauses Act cannot be brought in. Further, my lord, a track consignment report in itself does not amount to show due service, my lord, because at the end of the day, 25 of the DVX says that CRPC governs the procedure. So under CRPC, my lord, how so summons are deemed to be served, my lord, there has to be a proper report. A track consignment report does not amount to proper service. So this aspect aside, subsequently, my lord, the case gets decided ex parte. I have no knowledge of the same. Finally, after this case is decided ex parte, the aggrieved appears and files an application that let notice be issued to the respondents for realization of the area maintenance. Now, in this case, if your lordship notices, the case was originally filed by the aggrieved against the husband as well as his mother and brother. So it was filed against the husband, mother and brother. Order is against the husband. He used to pay rupees 5,000 per month, and there is also an order of payment of 20,000 rupees as compensation. Now, what the learned court does, now this order, if otherwise, even if the issue of perversity is not considered, is executable vis-a-vis the respondent number 1, that is the husband. Court issues notice to all the respondents, whereas there is no order against the other respondent. Again, my lord, there is no direction, but the court again, on the basis of a track consignment report, considers that service is duly served, and this time straight away issues bailable warrants against all the respondents. But the procedure is that, my lord, if there is a subsisting liability that has not been paid, so the first procedure is that the court has to take recourse to section 421 of the CRPC, distress warrant. If distress warrant is not executed, then the questions of warrant of arrest would arise. Straight away, the court issues bailable warrant of arrest, and that too not just against the petitioner, but also against his mother and brother against whom there is no order. So, considering the whole entirety of the matter, my lord, we came before this honorable court saying that first, this order issuing warrant of arrest itself is illegal because that is not backed by law. The complaint, the original DV case was not maintainable because it was filed after resolution of marriage, while suppressing this, because they filed a verification, they filed an affidavit, this was suppressed. Even in their evidence, when they adduced their evidence, they only mentioned that we have filed a divorce suit. They do not mention that by the time that divorce suit has already been decreed. Learned magistrate does not take any of this into consideration, and despite the fact that this marriage has been dissolved, this DV application is allowed. So our contention before this honorable court is that this very DV case itself is not maintainable, and accordingly we have come before this court under section 482 for setting aside the entirety of the DV proceedings because of the submissions which I have made. Rest I leave it to my learned friend.
Will remain part heard. I'm just writing. Now, date do I?
Let's first week of New Year, my lord.
After vacation.
First week.
After vacation.
After vacation.
After vacation, my lord.
Part heard go after vacation.
Let me look at my lord. Otherwise, not 7. My lord, item 43.
Say 7 and all.
Any day, my lord.
Free-time date is not possible. In fact, there are matters are being already listed. You go part
The month of January.
9th. 9th koi diba? Part heard 9 koi diba?
Item 43, some urgency is there. May I pray for listing on the Tuesday, my lord?
Yes, I don't know.
We are in custody since.
Last time while he has taken my contract, he said that it will be 16th of December. Yeah, he has mentioned that it will come after the meeting. But the matter is very hard. I think they got a stay order. They have taken a long time. I pray that I will mention before. To perform the date. I can 53.
What is this?
Consent. Prepon, though I cannot say prepon. No.
My lord, in item 42, my lord, there is an interim order, my lord.
Item
42, my lord.
Interim is there.
Interim is there.
Item
That
42. 42.
And my lord, I hope, my lord.
Item 42 interim is there.
My lord, may I get the order today, my lord? Tomorrow is the date fixed before the learned court below, my lord. 42, my lord. Proceeding was stayed till today, my lord. The stay may be continued and my lord.
Interim will be continued, your interim.
Item number 50, Lordship, here in item number 50, Lordship, here in this case, punishment is for 5 years. He already undergone 2 years, Lordship, in custody.
Now, what to say is, now see, listing is there only in your, before you.
Any date
So,
before vacation, Lordship?
Before vacation is
Any date,
just
We'll try,
becoming
Lordship.
impossible now.
If it
We have
reaches,
already
Lordship,
fixed matters a day. Is there any?
in a hearing day, Lordship, it may be fixed. Lordship.
Hearing date we পাৰিব নেকি? I don't think so.
If it does not reach, Lordship, I will not object to that. Lordship. Only a date, fixed date may be given. Lordship.
Just try. Item number
Item 50, Lordship, 50.
50.
Lordship, item number 21.
Okay, we'll try to accommodate you, but what today, 3, 4, 5 days are there only.
9-year
for
lordship,
vacation.
Zimma petition, regarding Zimma petition, your lordship.
Okay, we'll see to it. We'll try to manage anyway.